appeal part heard in the matter of McGaughey and another Universities Superannuation Scheme Limited and others.
Yes.
Good morning, my lord, my lady, my lord. Before I resume with claim 1, say we have 2 documents with us potentially to hand up. One is the transcript of yesterday. Unfortunately, it's been produced in the 4-to-1 ratio, which makes it very difficult on the eyes. It may be, I'm not planning to take the court to anything in the transcript this morning, so it's perhaps best left there for now. If something arises, then perhaps we can seek to bring it.
Well, speaking for myself, I'm very happy to have it 4-to-1 because it's less paper.
Well, exactly. That was, I think,
Yes.
that was the motivation. But unfortunately,
The most sensible thing is for you to get an email to our clerks, and then.
yes, no, I thought that had been done. I do
I think
apologise.
it has been actually, or has
Well, I
tomorrow.
haven't seen it yet, so
Yes,
no.
no, so-
Anyway, if we don't need it this morning,
No.
that's
And
not
the other is an extract, yet another extract from Lewin, Section 5, Directors of Corporate Trustees, which goes to the point, effectively Robertson Gill, and on whose behalf would such a claim be brought. Again, my plan is not to return to that this morning, but within the limited time clock I have left, to make good submissions, claims 1, 2, 3, 4, but I will come back to it
I think that would be sensible.
in the reply. I'm grateful, so let's move on.
Might I say, in relation to that, actually, when we do come back to it, you might want to also, at some stage, look at Article 71 in Underhill. I think Justice
Yes, but I think
Snowden's
that's
already referred to that.
That's the article my lord had.
Yes.
In the passage in Lewin, just to example, contemplates the arguments for and against whether the claim against directors would be a claim on behalf of beneficiaries.
Yeah.
We're going to move between the judgment and supplemental bundle 2. We can start with the judgment, where I was about to go for German yesterday, just to take the court to paragraph 131.
Yeah. 131.
131. The last 2 lines running on the top of the page. If the JNC had not consented to the deed of amendment, the company would have increased the contribution rate to cover its future liabilities. And with that in mind, the court can then go back to paragraph 60 of the judgment. This is the beginning of section Roman numeral 3 on the claims. To begin with, it's paragraph 62 to 66 of the judgment. Perhaps we can read quickly together. 62 details the 2017 actuarial valuation, shortfall of 7.5 billion.
Sorry, I'm sorry. Give me a page number. Sorry.
193.
I'm grateful, yes.
Sorry.
Core bundle, tab 16, my lord,
Yeah,
193.
Should we just read those quickly to ourselves?
Yes, that may be the quickest way. So it's 62 through to 66, I think.
Yeah.
Yes. So draw several points from that. The previous valuations point at 65 that no requirement at law, as I've said before, for there to be a valuation as at 31st of March 2021, and the fact that following industrial action, it's paragraph 66, UCU and the UUK set up a joint expert panel which produced 2 reports. That body sits out with the constitution of the trust and the rules.
So what relevance does it have?
That was the simple answer. It was a response to the industrial action in a practical way of moving matters forward.
What relevance does it have to your claim? Sorry, is really the question.
It's simply part of the process as to what was done in the background.
So what had happened here is there'd been a statutory actuarial valuation at 31st March 14, then another one at 31st March 17, and another one at 31st March 18. Is that right?
Yes, yes.
So there was nothing unusual in having the 2020 valuation, given that there'd been one in 17 and one in 18.
Well, what I say is the important point, 65, there was no requirement at law.
Well, that may be right, but the fact
Yes.
is that they were doing valuations more frequently than every 3 years.
And I'm going to come on to as to
Do
why.
you say it's a breach of duty to do a more frequent valuation?
Not necessarily, it's not that straightforward, but I say to do it then in the circumstances for the apparent motivation of doing it, say that is a breach. Section 171 and 172.
So what motivation? So are you going to come on to the alleged motivation?
Yes, well, I dealt with part of that yesterday, but I'm going to develop that now. Motivation was to prioritise the security of accrued benefits and reduce the benefit structure for future accrual.
So do you say anywhere that this is a breach of the director's duties to act bona fide in what they believe to be the best interest of the company? Are you saying they were acting other than in good faith?
I'm saying they're acting other than for the best purpose of the company and for the best interest of the company, and not for the proper purpose.
That's not the test. You either have to say if you're focusing on directors' fiduciary duties that you took us to 172, you either have to say they are not acting bona fide, i.e. in good faith. Do you make an allegation they are not acting in good faith?
That's the subjective element of it. No, but what I say is that.
And then the second question is they have to act in good faith in what they believe to be the best interest of the company.
But I say that they didn't consider that. They didn't have regard to the best interests of the company. That's the point. And in that basis, then, it's an objective test.
Why do you say they had no regard to it? You say they had no regard to it because they didn't come to a conclusion which is beneficial to your members.
No, it's not that reductionist, my lady. It's the fact that because of their priority on secured benefits, they lost sight of the overall purpose of the trust, which they administered as corporate trustee thereof, which would be the purpose of all members. It goes back to the equality of opportunity point I was seeking to develop yesterday. They were, we say, misguided and misunderstood the legal position. That's why I took you to the various documents which are summarised in paragraph 75 of the judgment yesterday. And that misconception that there was a priority at law, a paramount duty, a priority, the various ways it's put, that is what motivated them to carry out the valuation when they did, to assume the actuarial valuations they did, and with the aim of reducing benefits in the future.
They did have to protect accrued benefits, didn't they, under section 67?
Yes, but that's a slightly different point, my lady. No one is saying they could do otherwise,
No.
but that's a different point to the philosophical priority they give to different classes of benefits. Clearly, benefits which are accrued cannot be reduced.
No.
That's section 67. But that doesn't mean that philosophically they can, looking at things overall, use that as a basis for favouring the position of accrued members, say for adopting a particularly prudent approach compared with the position of active members and potentially future members as well.
So it's actually the adoption of conservative assumptions that you're complaining about.
That's the main essence of the complaint.
Okay.
Because that was a function of the date of the valuation and led to the position that absent future benefit changes, the contributions effectively threatened were unsustainable and unaffordable. supplemental bundle 2, it's tab 35. This is the from a USS Institutions meeting Thursday 10th of December 2020.
What's the USS institutions? We looked at this yesterday, but I've just seen the heading. What does that mean, USS institutions?
May I turn?
Well, it's a meeting, if you look, I think,
Yes.
if you look at the first line of what Jane K. Barker says, between the USS and the universities, isn't it?
It's the
employers.
It's the employers, yes.
It's employers,
Yeah.
thank you, I'm
Yes.
I
sorry.
think that's what it is.
Yes, that's certainly
It
our,
should be USS and institutions meeting.
yes.
Yeah.
Sorry, I'm just playing catch up. Sorry, I've been writing. Give me the tab again.
Of course, 35, my lord, page 279,
Thank you.
So it's a meeting with the employers.
meeting with employers.
So we looked at 282 yesterday.
We did, yes. We're going to turn to 329. It's the last paragraph there. In some ways, this discussion about how to tackle the valuation is perhaps a microcosm of many of those other discussions that are going on about how pain is shared between employers and employees, between the young and the old, between different groups of taxpayers. There are going to be many of these discussions over the years to come, and they are certainly, it says in square brackets, live in 15139. I assume that's a transcription for this valuation. Now the point is, my lady has helpfully prefaced just a few moments ago, those people who are either in receipt of pension or are deferred members, they can't share in any pain because of the effect of Section 67 of Pensions Act 1995. Pain can only be shared in the sense of increase of contributions and or reduction of future benefits.
So this is these are, sorry, I'm just struggling to understand what the purpose of looking at this is. These are closing remarks of a panel discussion.
Yes.
So what's
Yes.
relevance to this?
From
does this have?
From the chair of the trustee company.
Yeah, but she's chairing a panel discussion.
Yes.
I mean, so what are you saying that was a breach of her fiduciary duty or other duty to say that?
I'm not going that far, Lord. I'm saying that reflects the thinking behind the directors, their approach to this whole process.
Sorry, how? Even in the paragraph herself, she's just summarising a discussion between other people.
But we say the implication is that what is going to happen, and we'll see then what does happen, is that effectively the threat of unaffordable contributions was the leverage for benefit reduction.
Sorry, the threat of
Unaffordable contributions was the leverage for benefit reduction.
So are you saying that the directors threatened and used leverage, so you're accusing them of bad faith? I just want to understand what your
No,
claim
I understand
against
your
them
law's
is.
question.
I'm
I'm-
coming at it from the company law
Yes.
point of view.
Yeah, I know, I appreciate that.
What is your,
No transit.
what are you saying?
We're saying they did it not necessarily in bad faith, but of a misunderstanding of the purpose.
Well, not necessarily in bad faith.
Yeah.
Are you saying they did it in bad faith or aren't you? I mean, have you pleaded bad faith?
No. And I'm not reneging on that pleading.
So when you say threat and leverage, what are you saying?
Well, can I, and not seeking a doctrine question, but go to what happened and then try and substantiate the point that way. Effectively, what it is was various scenarios were put forwards on different bases, but the way it was done, we say, led inexorably to the fact that there had to be future benefit conclusions.
So you understand why I'm picking
Yes,
you
I
up,
do.
I hope, because
Yes.
the words threat and leverage are usually synonymous with
Yes.
some subjective bad intent, bad faith, which you are not pleading. So I'm not at the moment sure why you're using that language in submission based upon a paragraph that is reporting a discussion between other people. I mean, am I missing something somewhere?
Well, what I say you are missing, my lord, is the overall, the way the claimants put the case, to say that this is the reality of what was going on because of the misunderstanding by the directors of the purpose of the company, the priority to be given, that drove what happened through the valuation process, culminating in the valuation and eventually in the deed of amendment in February 2022.
Right, okay, so that submission is one you can make without the language of threat or leverage.
So you just misunderstood.
You're saying there was an innocent misunderstanding on the director's part of what you say the true legal
Yes,
position.
and I say that sufficed. The misunderstanding as to the legal framework and as to the purposes and or ignorance of the purposes of the company.
Right.
That's what drove the process.
Okay.
You ended yesterday by saying that they had forced the JNC to reduce the future benefits by amendment, which I took to be an assertion of improper conduct or bad faith. But, I'm wrong about that, am I?
Yes, my lord, it doesn't have to be, because as it, whatever given the motivation, what was done was effectively said to present a fait accompli to the JNC to say you have to reduce benefits. Otherwise, there is no future for the hybrid scheme.
But in fact, it seemed to me just now that wasn't what you were saying at all. You were saying they took a valuation when you're saying they shouldn't have done. But you say they did that in order to create a hiatus. I think you're saying that. But what you're actually complaining about, I think, is the conservative assumptions which were taken. Conservative assumptions drive the fact that about assets and deficit, which then drive the need for benefit reduction. But one needs to get back to why did they adopt conservative assumptions? Because it's those conservative assumptions that you're complaining about, because they lead to the need, it's said, for the benefit reductions. But you can only cut benefits because you haven't got anything else to do other than raise contributions, which they also did. And in those circumstances, there aren't any other cards in the hand. And so what you're actually complaining about is conservative assumptions rather than more generous ones. And that leads on to a situation in which your active members wouldn't have been put under such pressure. But it isn't really a choosing to damn one set of members as against another, because they, as you rightly said, they are the only people in the frame for the pain. And they always would have been. There was nothing that anybody could do about that because you have the accrued benefits. And so the real question is, isn't it, although, we're not here to determine that, is whether in fact it was right to apply conservative assumptions, because that's what drove everything else.
Yes, but
and so it's not a question of discrimination between groups at all.
Well, I say the motivation, the fixing of the actuarial valuation date at an inopportune time, and the actuarial assumptions adopted, they're all interrelated.
Yeah, okay.
And that's the key thing to bear in mind. And hopefully the totality of this will become clearer once we've gone through
but it's not bad faith. I'm sorry to interrupt you, Mr.
No, not
Grant.
at all.
It's not bad faith, but it is a misunderstanding of the need to look at all everybody in the round. But that brings me back to not quite understanding, because the only people who can suffer the pain are the active members in any event. So it's not a case of preferring one over the other, unless you're saying that the conservative assumptions were inevitably chosen only to protect the accrued benefits. Is that right?
Yes.
Okay, got it.
Right, okay, so can we, is there anything else in this document?
There isn't, my lord. We move on to tab 42.
Right, that's in the other one.
This is the update on the 2020 valuation. And we see in here, I'm reliant for a couple of points. One is the fact that UUK objected to the prudence proposed. But I'm going to come to that shortly. Immediately, I want to set out the various scenarios which were laid out.
Sorry, what page?
416, my lord. I hadn't given one, but it's 416.
Yeah.
Second complete paragraph down, beginning equally, if employers are unable to support any package of covenant support, the valuation outcome would be based on a weaker covenant. We have illustrated this in scenario 1 of the scheme actuaries report, which results in an overall contribution rate of 56.2%. So that was scenario 1 in its initial form. We move on to page 428. Again, there's reference at the top of the page, 3 bullet points to 3 scenarios. Scenario 1, no additional covenant support. Scenario 2, additional covenant support. Outline UK's clarification of the illustrative package. Scenario 3, sufficient additional covenant support to enable us to fund the scheme on the basis of a strong covenant, not sufficient to reach the top end of that range. The different scenarios reflected in the table below: 1, no additional covenant support; 2, UK package of covenant support; 3, adequate to fund on a strong basis. But if we move on to page 430.
But before we do so, this
Yes.
reference to covenant support is the wherewithal of the employers, isn't it? It's the support from the employers.
Yes.
Yeah.
Yes.
Just so that everybody understands
Yes.
what we're talking about.
And 430. Under the heading affordability of the current hybrid benefit structure. You see point 3 down, just so everyone's on the same page. Benefits already earned by members cannot be changed, and so deficit contributions will be required in any case. And the scope for benefit changes to reduce contributions is focused on the future service contribution rate. 2 paragraphs down, it says
Do you say there's anything wrong with that?
Well, of course, there's a statement of law. If the actuarial position is such as to require that, then that is required.
Yes.
The function, in my lady's point a few moments ago, of the actuarial assumptions adopted.
Yes.
2 paragraphs down, under scenario 1, with deficit recovery contributions assumed to be 19.2% of pay, it is difficult to envisage any meaningful defined benefit pension being provided under the hybrid structure. We assume alternative forms of pension provision would need to be considered. And 2 related points to this. First of all, we've seen it's primarily for the JNC, not the company, to make benefit changes. We looked at yesterday. But secondly, there's the movement from the previous iterations of scenario 1 to here to say it is difficult to envisage any meaningful defined benefit pension being provided under the hybrid structure.
So was your first point relating to the JNC, was that just an observation or a criticism? So were you saying that there's something wrong with this because they're not sorry.
Well, yes, it's a fair question, my lord. 2 aspects to it. First of all, to remind ourselves of the position yesterday, it should be primarily for the JNC to make benefit changes.
Right, assuming that's right,
Yes.
are you criticising them for not saying so?
I'm criticising them effectively for forcing, using that word, or setting out the position that there have to be a benefit changes. It is difficult to envisage any meaningful defined benefit pension being provided under the hybrid structure.
Well, you see, I'm slightly puzzled by that because the penultimate paragraph, if you look at the penultimate paragraph on this page, it makes it clear that
Yes.
they are thinking that they're not saying anything. This is for the J.
Yes. But
And if you go on to page 432, the indicative milestones remaining in the process are as follows. Number 1 is JNC decision on benefit changes.
yes, and that clearly that's said.
that's for the JNC and not for them.
Sorry, I didn't mean to speak across. There are clear statements to that, but we say it's the reality of what's going on that's important.
What the reality of what's going on is what?
Is the move towards benefit change coming from the trustee company?
What, this document? Well, how does this document show that? This document shows, as I read it, a discussion and them saying it's a matter for UUK and UCU via the JNC.
It's the passage I highlighted. It's difficult to envisage any meaningful defined benefit pension being provided under the hybrid structure. Doesn't say what it could have said. It's ultimately a matter for the JNC as to what it decides to do.
Well, that's what it does say in the penultimate paragraph.
Yes, but say not there. One has to look at that paragraph.
You mean we take that paragraph out of context
course not.
alone and just put it in a little sterile box and just ignore the rest of the document?
No, of course, my lord, that's contrary to all construction of any legal document or otherwise. But one has to look at the reality of what's being said there.
Well, it's an expression of opinion, but ultimately it's a matter for the JNC, isn't it? As they recognise. Okay, all right, so that's that.
Now, moving on to discount rates, and we've prefaced some of this already. We say the discount rates were unduly pessimistic, the consequence of increasing the scheme's liabilities dramatically. Liabilities being the sums needed now to pay pensions in my future. My skeleton seeks to set out in high-level terms the actuarial process and the elements of evaluation, assets, future pensions to be paid, and liabilities, which is the present sum estimated to meet those liabilities. Set out in paragraphs 46 and 47 of my skeleton, figure 1, the importance of discount rates to liabilities. Certainly with a fund of this size, small percentage differences can make huge changes to the amount of money estimated now to meet the liabilities in the future. And that leads on to the question of prudence, which is another way of looking at the conservative nature of the actuarial assumptions adopted. Prudence is a concept primarily introduced by Regulation 5.4 even of the scheme funding regulations. It says, in essence, actuarial assumptions must be conducted prudently. But it's not an absolute aim. So prudence doesn't trump everything else, because there, as we're going to see, there are different levels of prudence. One can be prudent, very prudent, etc., etc. And that has consequences for the cost of funding the scheme going forwards. It's not a case, and we've already seen this in one of the documents we've looked at, of saying that the assumptions were chosen with a view to achieving the objective of protecting the security of existing benefits. That can't be the rationale or the basis upon which prudence is adopted, namely to achieve that outcome.
Can you say that, read it again?
Yes, certainly. It's not simply a case of saying that I'm quoting from page 128 of the bundle. The assumptions were chosen.
Sorry, can we read along with you? That's what I suppose.
Certainly, I do apologise.
Can I read along with you? Because
No, I'm trying to expedite the process for what I hope are understandable reasons. If it's counterproductive, I apologise.
No, it's if you're reading a
Yes.
detailed sentence, I'd quite like to look at it while you
No,
read
well,
it.
I understand that. I do apologise. So, tab 26 of the supplemental bundle. My
So
lord,
it's back in
lady.
the other bundle.
I think I can't remember what the split is. I've got it double-sided. I think it's A.
And this is principles for decision making.
Yes,
We looked at it before.
we did look at it before.
I was just going to ask who this was produced by.
Internal document.
It's approved and adopted by a trustee board 18th of February 2020.
Yeah, okay.
So what are we looking, page 1?
It's the final bullet point, and the bit I was reading from, we should all read together, is 4 lines down in that bullet point. The assumptions were chosen with a view to achieving the objective of protecting the security of existing benefits.
I'm so sorry, I'm lost.
Page
So
128.
128.
128, final bullet point, my
Yes.
lady.
1, 2, 3.
The assumptions were chosen with a view to achieving the objective of protecting the security of existing benefits based on reasonable evidence, etc.
Thank you.
Yeah. All right.
And what the claimants say is that in relation to the statutory discretion prudence, the trustees have all the same duties they would have in relation to exercise of powers under the trustee rules. In other words, have to take all relevant matters into account. We say that the affordability or otherwise of future service benefits is a countervailing factor.
So do you say there's something legally wrong with this paragraph? I mean, I'm sorry,
Yes.
I'm struggling.
No.
I mean, I know you're quoting from it,
Yes.
but are you saying that this is legally incorrect, this paragraph?
Of itself, no, but one cannot, the point is that prudence is not an absolute objective which trumps all other considerations. So I'm simply trying to use the documents in the bundle to illustrate my proposition that prudence does not sit superior to or above all other considerations, one of which is the affordability of future benefits.
Where does it get to? What's the bottom line on at the end of the day? I mean, this is all what you're showing us is something long before
Yes, but yes, find the background. What it gets
what's
to
adopted is actually adopted.
what it gets to is that the directors adopted extremely low rates, in fact even consulted on the basis of yet lower rates, which were lower than the rates previously used. I'll give you the headlines and I'll take the call through the documents.
Yeah.
Without, we say, any justification for departing from the previous actuarial assumptions, contrary to the requirement under the regulations, and the consequence of adopting those incredibly conservative assumptions is to produce the liability which the 2020 valuation produced. So the liability and the deficit.
And are you saying that, what test are you saying that? Are you saying no honest director could reasonably have reached that result or rationally reached that conclusion? What's your standard of criticism of the directors? I mean, you've clarified you're not saying they were subjectively acting in bad faith, or indeed objectively in bad faith. What are you saying? Are you saying it was out with the range of honest views that directors could form? Or are you just saying it's a view that you would prefer that they didn't reach, didn't reach rather than one that they should have done? I mean, what's your, in directors' terms, what's your legal criticism?
We say two legal criticisms, actually none of which I think was trailed by your lordship. One of which was that this was used, this process and the adoption of these actuarial assumptions were done for an improper purpose, contrary to section 121. And also they were not in the best interests of the company, 172. So those are the standards by which we are evaluating what was done.
Well, we might unpick that. Proper purposes, we'll come back to, Howard Smith and Ample. When you say not in the best interests, that's not the legal test. The legal test is whether the directors acted in what they considered to be the best interests. That's the critical point I put to you this morning.
It is.
Are you saying that they either didn't act in what they believed to be the best interest of the company, which is tantamount to bad faith, or are you saying that this is out with the range of views that a honest and reasonable director could reach? Because that's the test you've got to satisfy.
It's neither in respect. It's a third possible option, which is that if the directors did not have regard to the success of the company, then it's an objective evaluation. So I'm saying through this process, because of their predisposition, the directors did not have regard to the question of whether setting the valuation rates they did was in the interest of the company.
Okay.
But we need also, going back to page 128, to look at all of what was said. You took us to part of it. It goes on 4 lines up from the bottom, specifically technical provisions must not be compromised to make a recovery plan more affordable. Put another way, the trustee cannot reverse engineer the assumptions to produce a certain outcome. so they're aware of that. Reasonable evidence does not require certainty on each or any particular point, and whether the reasonable threshold has been attained on a point is a matter of judgment for the trustees, having taken and considered appropriate expert advice. So they are aware that this is a matter of judgment which must be taken on the basis of proper expert advice.
Perhaps the easiest way is to start with the previous valuations, their discount rate and the prudence assumptions. You can turn, it would be in part B of Supplemental Bundle 2, to tab 49. This is the only document in this hearing bundle which sets out the actual discount rate used in the 2018 valuation. So the court is aware this is a document produced by First Actuarial, not LCP, so not the company or the scheme's actuaries, people instructed by other people. It's an after-the-event document, but I'm taking it simply because it sets out the valuation discount used in the 2018 valuation. The top of page 537, one sees CPI plus 0.92. So that was what was used for. Then, if we go back to tab 33 in the bundle, this is the consultation document we've looked at previously at page 227. Table 9.1 at the top of the page. This is the TTS, that's the tending to strong covenant. Bottom of that table, single equivalent discount rate, CPI plus 0.0%. Now, that never took effect, but that was what was consulted in this document. The figure that was actually used was a figure of CPI plus 0.29%. And again, we have to go to an after-the-event document to show that simply. That is tab 62 in the bundle. Again, this is an after-the-event document produced on behalf of the company, the interim monitoring and the financial management plan. It's to January 2022.
Which page?
First page is page 65, or the page initially, my lady, is page 654. And the figure given there, the single equivalent discount rate, is given as both the gilts plus 1.6% figure and also CPI plus 0.3%. That's a rounding up of the figure of 0.29%, which is the figure in our pleaded case reflected in the judgment. That is the single equivalent discount rate used in the 2020 valuation, 0.29%. Now that change from the figures adopted in the 2017-2018 valuation on the one hand to the 2020 valuation on the other involved an increase in the prudence and the centile which was adopted. And one can see that from the next document I'm going to take you to, which is tab 45. Document at the top, self-explanatory title, USS Briefing, Prudence in the 2020 Valuation. Page 473. penultimate paragraph. Sorry, no, actually, we start with paragraph with the second punch hole. For the 2017 even valuation, we included a margin around 0.3 billion for prudence and mortality assumptions. And we described the confidence level or percentile for the discount rate as being 67%, or at the 67th percentile. The latter implied a 2/3 probability that future investment returns would be at least as large as the discount rate, or alternatively a 1/3 probability that future investment returns would fall short. 2 paragraphs down, for the 2018 valuation, we again included a margin of around 0.3 billion for prudence and mortality assumptions, and we described the confidence level for the discount rate as again being 67%, or at the 67th percentile. So, effectively a 2/3 probability prudence. That was the bases used 2017 and 2018. We move on to page 476. One can see that the percentiles used, top of the page, and we see there 67% 2017 valuation, 67% 2018 valuation, and then for 2020 valuation, up to 86% pre-retirement, and a lower prudence for post-retirement. 86th centile, by the same logic as we saw in a few pages previously, means effectively a little more than a 5 in 6 probability the future investment returns would be at least as large as the discount rate. It's self-evidently a higher degree of prudence. I say on one mathematical perspective, it's twice as prudent, because the prospect of matters not coming out as one hopes has gone from 1/3 down to just under a sixth.
So if you just go back in this document to page 469, paragraph in the middle of the page, beginning with the conclusion from this comparison, and then the passage that's in bold, saying the level of prudence for the 2020 valuation isn't obviously materially higher than the 2017-18 valuations. Are you saying that's untrue?
Yes, we're saying that's wrong.
Deliberately untrue?
No, and I don't need to. I just say that that is incorrect. The important point is that the move from the 67th centile to an 87th centile is a self-evident increase in prudence. As I explained, what that, the reality of that means, it's not a linear progression. It means that the prospect of the outcome being less than anticipated is less than a half of what it was under the assumptions in 2017, 2018.
Sorry.
No.
I'm just very concerned that we are cherry picking through this document, which is extremely complex.
Yeah.
And as my lord, the Chancellor has said, there is that statement on 469. But if you go back to 473, you took us to what's said about the 2017 and 18 valuations. The bottom paragraph there says various things about the 2018 assumptions would have been, level of prudence would have been higher in certain circumstances. And there's a lot going on in the background.
Yeah.
Top of 474 explains about what happened in 2020 and why it happened. And there is some serious detail there.
Yeah.
I'm not suggesting we spend time looking at it now, but just to take up some headlines rather than the reason which is set out throughout this document about where, how one got to the position, I think is very dangerous.
Well, bear in mind that this is the application for the judge last year was an application for permission. On our position, we say we need to show a prima facie case. It's no part of the judge or this court's role to determine or make any final findings on this. The question is effectively whether this merits going to trial.
Absolutely, but you are
yes.
showing us these documents
Yes.
in order to encourage us to consider that the judge was wrong about prima facie case, and you're doing it by cherry picking. Whereas in fact there's a huge amount of discussion here, for example on page 475, and about the actuaries and what they've got from the actuaries and the models and the circumstances and the covenant and one thing or another. And so I'm just saying that I'm not suggesting that I'm going to decide, please not, but it's no assistance to me about whether the judge was wrong in relation to prima facie case if I haven't actually got the measure of the documents that you're taking little snippets out of, is what I'm saying.
Well,
And the judge would have read all these documents very carefully, I'm sure, in reaching conclusion that he did. Anyway, well, I think we should move on, Mr. Grant, because
certainly,
we're taking
yes.
a lot of time on this.
yes.
And if I can just note, so it's on the transcript when I come back to it, I mean, there's an explanation at some detail at 477 to 478 as to what prudence actually means, and particularly to illustrate my lady's point, you drawing attention to the emboldened text at I think my Lord the Chancellor drew attention to the emboldened text at 469, which you said was wrong, i.e. that the level of prudence in the 2020 valuation is not obviously materially higher than that in the 2017-28 valuations. In fact, if you go to the middle of 477, it says the amount of prudence in the 2020 valuation is not obviously materially higher than in previous valuations given the circumstances, and the qualification given the circumstances is important, and then it sets out why by reference to the fact, which must be right, that the markets in certainly 2020-21 were considerably more volatile than they had been in 2017-2018. The difficulty with this, as my lady points out, is this is a detailed analysis. And if I'm trying to fit it into my company lawyer's box of breach of duty, even a prima facie breach of duty, I think you have to go beyond, quite some way beyond saying I disagree with, or that there's some actuarial error in a single sentence expression in a document like this to justify saying that the directors were acting either for improper purposes or in breach of their fiduciary duties. That's the question.
And our answer to that is to say it's a combination of the valuation date adopted when markets were extraordinary, to use the words used by USS, coupled with the assumptions made. What is said is that they did have regard to the stock market recovery after March 2020, but they did that supposedly by reflecting that in the discount rates. But what we see is a discount rate of 0.29% adopted, lower than the ones for the 2017-2018 valuation. We say without justification. And the combination of those factors against the backdrop of everything I've already said, we say that is what made this process improper, with the consequences it led to. Now, there were criticisms of these assumptions and increased prudence. One by the employers, the other by Aon. The comments of Aon are in Supplemental Bundle 2, tab 50, 50.
Who were Aon instructed by?
Sorry, I missed your lady's question.
Aon, who were they instructed by?
They were instructed by the employers.
Thank you.
Yes. And page 546, this is a document which isn't reflected in the judgment. And again,
This is commenting on the document we've just been looking at tab 45.
Yes. And one sees in the comment in the right-hand margin, takeaway point, our view is that a higher discount rate can be justified for a resolution to be found to the valuation. The final package, including covenant support and benefit reform, will need to include movement from the USS trustee on the prudence applied.
Right.
So the summary at 451 says, our view is that the trustee is being overly prudent on the pre-retirement discount rate, but we acknowledge that this is the trustee's decision to make. So they're not saying this is being done on a, erroneous basis, still less improper. And they're acknowledging it's an exercise in judgment, isn't it?
No, and of course that's the case, but that wasn't what they were instructed to do. They were instructed to comment on the actuarial basis. I'm using that as part of the argument.
So where do the employers criticise this?
That's in a different document. Sorry, I've lost the reference. Give me a second, I'll try and come back to this. Yes, tab 42, page 419. Again, it's part of the update in the 2020 valuation. Bottom heading discount rates, it's the final paragraph on that page. UK said employers broadly supported a post-retirement rate of gilts plus 1% PA, but considered a pre-retirement rate of gilts plus 2% to be incredibly conservative, finding it difficult to see the rationale for increasing prudence relative to the confidence centile adopted in 2018. Continues, UK reported that a number of employers also said the pre-retirement discount rate should be fixed relative to CPI in the line comments made with the JEP. No point of principle means we want to increase the level of prudence for the 2020 valuation. So it continues. So you have comments from the employer there, comments from Aon in the document I just took.
Yeah, but if you read on, this is exactly the point my lady was making. If you read on, they go on to justify the approach that was adopted, and make the point that in effect this was all done on the basis of actuarial advice. So presumably where this ends up is that the employers accept the rate.
Well, they don't have any part to play in it. It's set by.
But the JNC does, doesn't it?
Not in the.
Because
unilateral power.
UUK, which is the employers, had I forget who had how many. One of them had 5, and one of them had 4. The unions had 5.
I think employers had
4.
Right, I think it was equal, and there was a casting vote.
Well,
yes,
that's right. But I mean, the fact of the matter is that
but they have
able to just make a decision within the JNC.
My lord, with respect, that's wrong, because the JNC had no part to play in the actuarial valuation decision under Rule 76. Have a role in any benefit reduction under the power of Amendment Rule 79, but not in the valuation.
But
To the extent of their involvement is to be consulted. There's no power of veto.
Sorry.
This was all. Sorry, I'm sorry.
No, I'm sorry.
No, I was just going to say this was all approved by the pensions regulator as well, wasn't it?
And at page 420, I think it's what the Chancellor was referring to. At the end of the first paragraph, it says, overall, we and the scheme actuary believe the level of prudence is appropriate, given the conditions prevailing at the 31st of March 2020.
Well, that then begs the question why the 31st of March 2020 date was adopted, given the conditions that pertained at that time. As said before, in its common ground and reflecting the judgment, USSL wasn't compelled by statute or otherwise to value as at the 31st of March 2020. The only obligation was to provide an actuarial valuation by a date no later than as at 31st March 2021. That's acknowledged by the bundle. The company has referred to a commitment it made to provide a valuation before as at 31st of March 2020. That's a unilateral undertaking. It's not enforceable, renegable by it. The company also acknowledges that it was possible to produce an annual report under Section 224 of the Pensions Act instead of the actuarial valuation. As I said yesterday, but to repeat, a report, shorter document, doesn't drive change would be required clearly in the absence of an actuarial evaluation, but could clearly have been done instead of it. And there wouldn't have been the valuation and the consequences which flowed from that. That ability to produce an annual report was recognised in the board minutes. I can take the court to them briefly. Tab 29.
But again, are you saying, sorry to
Yes.
go on
No,
record,
not at all.
record, you're not suggesting that it was decided to have an actuarial report on 31st of March 2020 in bad faith?
No.
I don't understand you to be suggesting that no reasonable board of trustees, directors, in fact, let's be accurate, no reasonable board of directors could have taken that decision.
Well, that's not the way we're framing the accusation.
No, but I'm trying to understand
Yes.
your accusation, because I think this is what we're doing at the moment.
Yes.
I'm trying to understand your accusation in a company law
Yes.
framing, because what you do in your pleading, which we haven't been to yet,
Yes.
and I will drag you there eventually if I may,
And I know exactly what you're going to take me to. Yes.
is you just say, well, here's a lot of things, and
Yes.
it's in very generic terms said to be an unparticularised breach of a number of
Yes.
very broadly expressed duties.
That's paragraph 82. But paragraph 81 sets out precisely what we complain about.
Yes,
the
but
structure
you
of the
don't.
fruit.
But the problem I'm having is joining the dots because between the facts of which you complain and the respects in which you say they constitute a breach of the duty, and I don't actually at the moment find the particulars. And this is the difficulty, that you're not identifying in corporate law terms why you say this is a breach of the director's duties.
Well, my lord, if I'm failing to do so, that's clearly my fault. That's what I'm seeking to do so. In terms of anchoring the allegations that are being made, having regard to the statutory obligations under sections 171 and 172, against the context of the Articles of Association and the purpose of the company, which clearly inform how, for example, the purposes are to be viewed and the success of the company is to be measured.
But if the directors, putting it even more broadly, I mean, if the directors, act on actuarial advice, after a extensive debate with the interested parties, I really am finding it very difficult to understand how you say, for example, they're acting in breach of their fiduciary duties in doing that. I mean, there is room for difference of opinion between actuaries, plainly.
Yes.
But it's a very strong allegation to make to say that a director who has an expert actuary that is engaged in a vigorous debate with other actuaries and then follows that advice, which I understand is what's happening here, is acting in breach of fiduciary duty.
For example, the decision to fix the valuation date as at 31st of March 2020, that was one taken by company,
Yes.
notwithstanding the economic circumstances, notwithstanding the lack of legal obligation to do so, notwithstanding the objections of some of the employers to do so as of that date. And we say, for the reasons I've said, that does constitute a breach of those duties, because valuing a scheme at an inopportune time and valuing it having regard to extremely conservative actuarial figures, we say, not justified in comparison to the figures given in previous valuations, we say those are breaches of the director's duties under section 171, section 172. Because they're not done for the purpose and they're not done to promote the success of the company. Now, what I was about to come on to is that it's said in the witness statement of Mr. Atkinson that the date of the valuation was struck. And I can take you to the statement if that would help, but that's effectively what he says. And the reality is there is no statutory concept of striking a valuation date. A date can be fixed in advance or retrospectively. One can initially set out to have a valuation date and one date and then decide not to. As we say, it should have been done in this case. It's not the fact, and this is really an adjunct of the unilateral undertaking point, it's not the fact that just because they said in 2018, we're going to have a valuation as at 31st of March 2020, that doesn't strike the date. That doesn't make it absolute and invariable. Clearly doesn't. And there is nothing in the legislation which prevents the directors of the company from taking a different valuation date, subject to the absolute long stop of there being in default an actuarial report as at 31st of March 2021.
But there's nothing that prevents them doing it on the 31st of March 2020, any more than the 31st of March 17 or 18.
Other things being equal, no, but we say other things weren't equal because of the conditions. Why did they decide to keep to that date, given that market conditions were extraordinary? Paragraph 88 in Justice Leech's witness statement, quoting from a company document itself. Why was that done? And we say the combination of fixing a date when assets were suppressed because of the extraordinary volatility of the market at that time, coupled with the extremely conservative assumptions led to the consequence of a deficit in the order of 16.1 billion, many, many multiples of the previous deficit.
But, sorry, I mean, call me simplistic, but the market suddenly hit a massive turmoil,
Yes.
You know, because of COVID. If you're a trustee, why is it wrong to say, crikey, you know, we haven't got a crystal ball, we don't know how long this volatility is going to last. At the time, we don't know whether the market is going to get better or for worse. Isn't that exactly the time you might want to adopt a prudent approach? Because otherwise, you run the risk of actually pursuing a policy which is inappropriate because you're in a volatile market and a persistent volatile market with an approach which is not as prudent as it needs to be. I mean, what's wrong with at least taking stock, given the volatility of the market?
The problem is that the assumptions made as at 31st March 2020 were on the basis of a 30-year forecast. So whatever volatility happened with COVID, at the time one didn't know if it was going to be a month, 2 months, 1 year, 2 years, that volatility would even out. But the freezing of the position at that specific time is prejudicial, given the long-term nature of the scheme, open nature, given the long-term 30-year plus investment basis upon which the assumptions were made.
The prudence, I mean, that question of prudence in the circumstances was exactly the point that the actuaries debated amongst themselves. And Aon, for example, said, well, this is, you know, essentially it's a matter of judgment.
But it begs the question,
But
why?
If you look at page 457, tab 43, USS briefing why we decided to proceed with the 2020 valuation.
Yes.
You see there that they say that they refer to the position in early 2020 when the pandemic was already on its way, as it were. Financial markets reacted to disruption and uncertainty, which we can all remember. And then at that time, they say, we believed that continuing with the 2020 valuation was the most measured response to addressing the scheme's deteriorating funding position. And they go on to explain that. And then they say, nearly 12 months later, because this is the 3rd of March 21, they still believe that continuing with that was the right course. Well, how can they be in breach of their duty under Section 172 of the Companies Act in those circumstances? You may not agree with it. Your clients clearly don't agree with what was done. But this is they believe in good faith that this was the right thing to do.
and as they point out, also at page 457, the last bullet point, they were required to do a valuation as at 31st of March 2021 anyway.
Well, yes, well, that's the point I'm making, but that of itself isn't unsubstantial. One looks at the difference, the recovery in assets between 31st of March 2020 and 31st March 2021. That's in the magnitude of £20 billion from recollection.
See, well,
Significant sum.
it's a very unusual, I mean, I inhabit the corporate world more than the pensions world. Let me just put it
You're no
bluntly.
stranger to it, my lord.
I'm no stranger to the company's world, and it's a very unusual case of breach of fiduciary duty to level at directors who are, as it were, informed by this level of introspection and debate, and are explaining themselves in a glare of analysis from actuaries from all sides. It's a very unusual allegation to claim breach of fiduciary duty. Just out of curiosity, did anybody in any of these discussion documents ever say this is something that is wholly inappropriate for directors to do? They are not complying with their duties under the Companies Act, or indeed any pensions legislation. I mean, all this expert scrutiny, did anybody anywhere say anything remotely similar to what you are now alleging?
Taking a stage response to that, I can think of nothing that jumps out. That wasn't the prism through which people were concerning directors' breach of duties.
I mean, I'm not saying it's impossible for
No.
directors to commit breaches of
No.
fiduciary duty in the full glare of publicity, but it's not the
No.
most obvious.
No.
It's not the most obvious thing that.
No, but going back to my lord's point yesterday, that a breach of trust may not necessarily involve a breach of duty by the directors. There'll be a close commensurity between the two of them. And to the same extent here, if, say, there's a breach of trust by the trustee, hand in glove goes breaches by the directors of their duties.
But that's not the reaction of any of the professionals engaged in this debate.
But with respect to professionals, they wouldn't have been looking it through the corporate prism that your lordship is.
Well, but they may well have been. The whole ethos of your claim is that the directors acted in breach of fiduciary duty to the company in causing the company to act in breach of trust qua trustee. And there were certainly people who could have been expected to shout about that second limb, aren't there?
Well, clearly there was opposition to
No,
the changes
it's a vigorous-
on lots of levels, whether it's the strikes or everything else, or the things we see in the
It's a
bundle.
vigorous,
Yes.
well, I see at the moment, I'm seeing a vigorous actuarial
Yeah.
pensions debate. But I'm not seeing anybody, in essence, making the allegation you're making or anything remotely resembling it.
But
And Aon,
Assuming-
the furthest Aon goes, they say, well, we don't, in effect, they say, well, we don't agree,
Yeah.
but it's all a matter of judgment for the directors.
assuming my Lord Justice Snowden's point to be correct, that no one behind me has been able to direct me to anything in the last few minutes, that doesn't preclude the claimants from bringing those allegations now if they are substantiated. And their case is the one I've been seeking to make good for the last day and a half, that there were in the circumstances of this.
I mean, you know, it wouldn't be the
Yes.
first time that everybody had missed something obvious. But the more people and the more sophisticated people looking at it, the less plausible it is that something obvious was missed.
Well, at the risk of encroaching the rage of the court, the Robertson-Gill point yesterday, which had evaded the parties, is raised that happens frequently in litigation. So maybe that amplifies your lordship's point or not. I'm not sure.
Okay.
No, Mr. Grant, I really think we should move on.
Yes, exactly.
Sorry,
No,
I plead guilty. Don't worry. That was a
no. Well, I was thinking perhaps such a roundabout way, we've covered what I want to say in terms of ground 1C. I'll deal with ground 1B briefly. We say that an abuse of power by the directors in pursuing an improper purpose furthered their own ends within the meaning of the test in Manco, as amplified in Aberaya and Harris and microfusion.
Sorry,
I
could
see.
you say that again? So
Certainly.
you're saying it's an abuse of power by the
So
directors?
the misuse of power by the directors
Mhm.
and or the acting other than for the purpose of the company,
Mhm.
I say automatically constitutes an exception or comes within the exception of Manco as subsequently interpreted. Clearly, if the court isn't with me on the point we've just been discussing, the question falls away. If I say in converse, if it is, then almost by necessity, the exception to Foss and Harbottle is made out. And in relation to ground 1A, this is whether there's a requirement as a matter of standing reflective loss. The starting point is that there isn't, and if so, that question does fall away. But if loss is required, we say the loss has to be seen in the context of the purpose of the company. It's not a for-profit company. One has to look at the purposes, and we say that the failure to comply with those purposes, the failure to act for the success of the company of itself is a loss looked through that prism, which satisfies the requirement of ground A, of lim A, the threshold question of reflective loss.
So you don't go on to say acting in a way which puts the company in a breach of in a position of breach of trust causes the loss.
That's my next point, my lady.
Okay.
The first point is I say that the very essence of what I've just said is sufficient. If I'm wrong, the very point my lady has made applies. That the exposure to the breach of trust claim is a loss. My lord, I think that concludes claim 1. Move on to claim 2, the discrimination claim.
Okay.
We covered quite a bit of this yesterday.
Sorry.
So
Can I just
certainly.
when you come back to your pleading, which I hope you do, perhaps you will be able to tell me how much of your pleading, and in particular how much of paragraphs 106 to 110 you are actually pursuing in the formulation that you've just given.
Well, it's just it would be better use of time if I do that later on.
Yeah. I just don't want it to be.
May I take the notes of the paragraphs? It was 106 to.
Well, it's page 335 and 336
Yes.
of the core.
It's
which I
the
understand
draft
are
amendments, yes.
Draft amendments.
Claims 1 and 2.
Yes.
Claims under claims 1 and 2,
Yes,
because
I
you
understand.
are making allegations that directors pursued their own interests and benefits. I'm not at the moment understanding that you've actually addressed the question of what quotes of their own interests the directors were pursuing. I mean, I hadn't understood that to be part of what you've been submitting.
That's partly because now focusing on the way that the test is put in Harris, furthering their own ends as opposed to interests.
Well, I'm less interested in how
Yes.
some other judge put it
Yes.
in another case. I'm more interested in what you are actually alleging.
Certainly.
Because these pleaded allegations seem to be allegations which are close to allegations of impropriety in terms of pursuing personal interests rather than the interests of the company. There's allegations of perversity, and I don't really understand that anything that you've gone to at the moment really addresses the gravamen of those pleaded allegations.
Yeah, I'm speaking for myself, reading paragraphs 106 to 110. I assume that they were an allegation that the directors were acting in bad faith. It's difficult to see what else they can be. I mean, equitable fraud is a very broad concept.
Yes.
It's still the concept of acting in bad faith.
Well, my lord,
That was the point that, I mean, Sir Robert McGaughey makes the point in the context of Estamco and the Greater London Council. I don't know, I can't remember now if he actually says they were acting in bad faith, but he certainly is extremely critical of what was clearly an absolutely blatant political decision.
We can check it, but what some of the other cases say in relation to that is that fraud is difficult to prove. This is Justice Templeman and Daniels, so one doesn't have to go that far. Crucial point in S. Manco with respect is that it's the abuse of power.
Yeah, but
It's use of power.
look at under 9, for example.
Yes.
You are saying that
Yeah.
their actions were perverse, and then you go on to say the only rational reason why the directors would want, quote, to project a large deficit in the scheme, ignoring substantial subsequent increases in the scheme's assets. I'm not sure quite what that means instantly. Was to force the JNC to cut terms on which benefits would be accrued in future. I mean, that is an allegation of subjective state of mind of the directors, isn't it? I mean, what? Anyway.
Yeah,
I do want you to come back and explain.
I'll come back, but I'm not going that far.
Okay.
Yes.
Okay, well, let's move on.
Discrimination. Now, we covered part of this yesterday, understanding the mechanics of the claim. And we start out with saying that the judge misunderstood the claim. The claimants are not seeking to bring a discrimination claim themselves. Rather, they're seeking to bring a claim on behalf of the company, which has been exposed to prospective discrimination claims by those in the relevant cohort or cohorts because of the director's actions. The matters which form the basis of the valuation allegation in Claim 1 led directly to benefit cuts introduced in 2022. We say they amount to indirect discrimination as they create a particular group disadvantage to younger members who are more likely to be female and or an ethnic minority. We say the cuts were neither necessary nor justified, and they have exposed USSL to the risk of litigation from affected members. The judge was rather caught up in the question of whether it was necessary to prove the director's mens rea even in relation to the discrimination aspect. And I say he was wrong to do so. All the claimants will need to do at trial is to show that the directors are in breach of their statutory duties, which breach has exposed USL to loss in the form of the prospective discrimination claims.
No, you have to show that they either used their powers for improper purposes or they acted other than genuinely what they believed to be the best interest of the company.
But not necessarily by reference to or with the aim of discriminating. If the court is with me in relation to Claim 1, I say that's really the gateway for making out the breaches of duty against the directors. And that's had certain consequences, one of which is exposing the company to the prospect of these discrimination claims. In terms of the actual discrimination...
Just to be clear, I mean, are you saying it's impossible for a director to take a view that he's acting in what he believes to be the best interests of the company, but which has a byproduct of exposing the company to claims for discrimination?
No, I'm not going that far, and there may be other facts in which it's perfectly possible to have that, but I'm saying on the facts of this case that was what was done. These changes were not justified, were not necessary, having regard to the actual reality of what we've just been discussing. But what happened was that in consequence of the discount rate adopted and the valuations at the 20th of March, benefits for future accrual were altered in 3 ways. It's set out in my skeleton. We have the deed of amendment in the bundle, but I can, to save time, just summarise the 3 changes. 1, the reduced salary threshold reduced from just under £60,000 to £40,000. What that means is this. All pensionable earnings up to £40,000 result in defined benefit pensions. Once an employee hits the 40,000 threshold, any earnings in excess of that go into the defined contribution element of the scheme. Secondly, in relation to the defined benefit part of the scheme, the accrual rate was reduced from 1/75th to 1/85th of salary for prospective service office only, for obvious reasons. So what that means, clearly is for every year of service up to the trigger date April 2022, the employee, the member, earned 1/75th of his or her salary. In relation to service thereafter, is reduced to 1/85th, so the accrual rate slows. And thirdly, a reduced inflation cap on annual increases to pensions in payment. Which will the court be familiar. Pensions actually in payment to pensioners increase annually, having some regard to inflation. The reduced cap introduced is a 2.5% in comparison to a much more generous position, which might have been up to 10% for previous pension service. And the claimants say those changes.
Sorry, what was the formula before? It's now it was a cap of 2.5%, which was introduced. What was the formula before?
Up to 10%. It's a slightly variable.
No, but was that actually how it was framed? It was said up to 10%.
I can't remember.
I doubt that it said
check
that.
the precise words. That's
But
important.
don't worry.
No.
Come back to it.
Point is there was a significant reduction in it. We say each of those changes constitutes indirect discrimination, contrary to sections 19 and 61 of the Equality Act 2010. Now, what's important to understand, I'm going to take the court to just try, in the interest of time, one authority, one of the most recent ones, which happened my learned friend appeared, to explain the difference between direct discrimination and indirect discrimination. But by way of headline, direct discrimination is where the character.
Do we need that?
Sorry?
Sorry, I was just in the to save time. Do we need that? I'm not sure. Do you?
No.
Why do we need that?
I think we,
So
I think we
the-
Right or
understand
wrong,
that.
we do understand the difference between the
Yes.
two. You're either right or wrong on this, and you rightly accept that if you're right on claim one, then this follows.
Yes.
If you're wrong on claim one, then this falls away.
Yes.
So I'm not sure why
No.
I'm spending time on this.
No. Okay, well, so be it. Well, the simple point is exposes the risk of discrimination claims based not on the reason for the treatment, but on the particular disadvantage to people with certain characteristics compared with other people who don't share those characteristics. That's the critical difference between direct and indirect discrimination.
Mhm.
And taking the accrual change, for example, someone who joined or commenced service a couple of years ago, we say is correspondingly more likely to be young, or female, and or ethnic minority, will have a particular disadvantage by reason of the reduced inflation cap or the accrual rate change. So
And
that's
one
the
of things-
basis.
And one of the things the judge said, wasn't it, was that there was no evidence in the bundle about surveys about whether this is so or not.
And those, I say, are matters for trial, but the court can take judicial notice of the fact, and indeed that's exactly the way my learned friend ran argument in the FBU case in the bundle. I'm quoting from words in there, that younger and correspondingly more likely to be female and or ethnic minority. So I say that criticism of a lack of statistics doesn't hold good. It would clearly be critical to any eventual trial in order to establish whether the reality of the situation, but I say for present purposes, isn't necessary. And we say the reason it changes was saving money, but purely saving money is not of itself a legitimate aim. Sometimes it's discussed in the language of employment lawyers as costs plus. We say these are all matters which would have to be explored at any trial of this action to determine whether there was a real risk of discrimination claims. And the final point to make perhaps is that, at least on this heading of it, none of this is predetermining the underlying employment tribunal claims. Simply establishing there is a risk of them. In the same way that any grant of permission today, or in this case or in any other case, does not bind the court hearing the substantive trial of the matter. It's a different threshold. And that's the point which, with respect to say, the judge lost sight of in his understandable concern not to alter or taint the position of the underlying discrimination claims. And what I say in relation to the prima facie case and the prima facie test of improper benefit for claim 1, I repeat effectively for claim 2. And likewise, the test of standing.
Sorry.
And it's exactly the point my lady made some 10 minutes ago. Even as a fallback, the exposure to the risk, the exposure to the prospect of claims, I would say self-evidently a loss. And we debated this point yesterday, my lady and I, in terms of we saying that that then caused a loss to my clients reflective upon the company's loss, and the answer is yes. Not in the diminution of benefits per se, by other means.
So did you say in that, so maybe I misheard you, did you say you made an argument about improper benefit? So what was the second of the 3 points you just made?
Well, what I was seeking to do was to carry across the arguments I've made in relation to claim 1 to claim
You were.
2.
What was the second one?
That was the improper benefit I thought that
Yeah.
Mr Grant said first. He carried that over.
Yes.
The same arguments in relation to improper benefit ground B from what he'd said in claim 1. Then he was going to standing, which is ground A,
Yeah.
and he was explaining about loss and exposure to claims. That's as far as I've got.
Yes.
Improper benefit to who?
Again, it's exactly the same point as for claim 1. The furthering their ends, we say that's the test.
Sorry,
Yes.
whose ends? Who's furthering their ends?
Who the directors are.
Furthering what ends?
So what ends are the directors furthering in this respect? I don't understand what ends they are furthering. Your assertion, is this right, is that they made a decision which had the potential to expose the company to discrimination claims because they failed to take into account the potential discriminatory effect of what they were doing. Is that right?
That's a byproduct, but that failing to take into account the discrimination isn't part of the ends. The ends were to have the valuation leading to the benefit changes to promote the security of accrued benefits.
Yes, but sorry, are you saying that, sorry, when you're using the word improper benefits, you're not saying the directors were improperly benefiting themselves?
No.
Sorry. So when you said improper benefits, I was trying to ask the question.
No, yes.
Who's being improperly benefited?
Well, I'm putting it in a slightly different way. I'm saying that that's actually not the question. The question for the exception to Foss and Harbottle is did they further their ends, the directors? And it's exactly the same points I'm making in relation to claim 1.
So which ends
Yes.
of the directors are they furthering?
They're furthering the ends to their misconception that there was the priority of accrued benefits.
If I act to
Yes.
further an improper end or further my own end, that is suggesting that I have positively in mind to advantage myself as a process. I mean, the Asplin Co is a case where the council
Yes.
were trying deliberately to use their voting power to prevent the company from enforcing a contract that the council had entered into but wanted to get out of,
Yes.
broadly speaking. Yeah, it was a conscious decision by
Yes.
the council to misuse their control of the company to stop the company enforcing the contract. That's what
Yeah.
Sir Robert McGaughey was talking about, as I understood it, when he talked about furthering one's own ends. That's the equitable fraud. It's the fraud on a power. It's the abuse of the power for purposes for which it was not conferred. The power in that situation being the votes of the majority shareholder.
Yeah.
I'm struggling to understand the parallel with what you are asserting against the directors when what I understand you to be asserting is that by oversight they failed to appreciate that there was a potential consequence of what they were doing in terms of a discrimination claim. It's a completely
saying
different
by
allegation.
a misunderstanding of their role and the priority points I took the court to yesterday afternoon, that led them to prioritise accrued benefits part of the background to leading to the valuation, the date, and the actuarial assumptions.
Yeah.
I say that's the question. In terms of furthering their own ends goes further than interests. Going back to the factual variation I suggested yesterday in Estmanco, imagine if it had been the directors who resolved not to proceed with the claim against the GLC, not the GLC, the shareholders. In my submission, that wouldn't have made any difference. Even if the directors of the company, Estmanco company, hadn't benefited in the narrow terms which was in contemplation. Ultimately, furthering their ends includes, we say, ends which are inconsistent with the proper purposes of the company and the success of the company. And that is exactly what we're saying happened here.
And that's what you said in relation to claim
Yes.
1, and you say it in relation to claim 2.
Yes.
And I think the point that my Lord Justice Snowden was making is it not different in claim 2, because it's just a consequence of all of those things that they didn't, you're saying, didn't appreciate that they had exposed the company to discrimination claims. And I think what you're saying is it's all part and parcel.
Well, it's simply an aspect of the loss that flows from it.
Yeah.
And perhaps with hindsight, we would have pleaded it as an aspect of the loss of claim 1 rather than a self-standing thing, which may well have complicated things. But that's the point, and that's why I set up by saying that it's not a question of whether there was any mens rea in relation to discrimination. There being no requirement of mens rea in discrimination law at all. Why would one have to superimpose that here? One doesn't. One's looking at the primary events which occurred, determining whether or not there is a prima facie claim, whether there was action to further their ends. If so, whether one of the losses which flows is the loss of the exposure to the discrimination claim.
Right. Well, I think we should have a break
Yes.
for 5 minutes. When we come back, I'd quite like to hear from both of you as to what the progress is on this case, because I'm really quite troubled. Because I think when we started, the assumption we all had is that you would have finished your submissions by about 11:15 this morning, starting at 10:30. You've got 2 more claims to deal with.
Yes.
Perhaps you'd like to think about
I'll
that.
speak to it.
All right.
constitutional function of the articles is to provide university staff with benefits, but they seem to be doing something else materially.
To say their ends are other than
And that is false confidence. Section 174 does not require it. So that's quite right about this. Section 172 is just subject to done. Just as Snowden's held up on this idea of fiduciary duty, actually, conceptually act in accordance with the Constitution. So common for us to get out. So it brings out reinforcing as much whatever it is in the articles associations. So directors was build out is on the subsidiaries and they changed the constitution so that they but that's Richard says you're absolutely right on that. Don't panic. You've got a 75-year test. Yes, I think it's rather than interests. Don't fill this into a company. Just say to him, section 1B is what he's got. And section 1 is just why you take it to exam. Yeah, well, Claire's court.
David, tell them how he's running.
It's not supposed to be a difficult answer. It's entirely within my gift. I'm aiming to finish by 12.
I think if I long as that gives you 15 minutes.
Okay, no, so I'm not then. Yeah, so yeah.
All right.
My lord, I've just spoken to Mr. Short. I shall endeavour to finish by 12:30.
Does that give you enough time, Mr. Short?
Yes, my lord.
Right.
I'm grateful to all. Claim 3 I'll take as quickly as I can. This is a claim about the increase in costs of the scheme. One can see from paragraph 109 of the judgment.
It's fees directly to the directors and investment management costs.
And we've set out tables in the skeleton trying to summarise the cost increases, but perhaps the easiest way to look at them is in Supplemental Bundle 1, annexed to the witness statement of Mr. Gibb. So Supplemental Bundle 1, that's the witness statements bundle, tab 3.
Am I not right, before we go any further, that all remuneration has to be approved by the JNC?
Sorry?
Am I right that all remuneration has to be approved by the JNC?
Maybe check that. Yes.
I don't know whether I'm right or not.
The
Well, maybe Mr. Short's plans now.
Yeah, I understand the director's remuneration
Yes,
Has to be approved by the JNC.
on the JS.
yes, thank you.
Right,
So-
so what are we looking at in this statement?
tab 3 page, where it's actually the appendix to page 41 of the bundle. That summarises the costs. It's in counter-chronological order, but one can see reading from right to left the increase, the dramatic increase in the total operating costs on an absolute basis, on a year-by-year basis, compared with the assets of the scheme. One looks at 2007, and for the cost claim, we're talking in millions, and assets, we're talking in billions, effectively. You can see 38 million as opposed to 30 billion in time, ending up, say, claim 2020, 160 million total operating costs, the highest figure, against 67 billion. So there's been a more than quadrupling of the costs, but more than a just over doubling and a half, 2.5 times, but more than that, of the assets of the scheme.
And then it's down again in 2021.
And then down again, yes. One has to look at the overall trajectory. And there may be explanations for it being down in 2021 as a function of COVID and other things. But nonetheless, the overall trajectory, up to that point, it had gone up absolutely every year. And as a percentage of the operating costs of net assets, one can see, although it isn't linear, and there's been some variation, nonetheless, the prevailing trend is for an increase in that ratio or the percentage with time.
Why has the company suffered any loss as a consequence?
Why has the company
Yeah.
suffered any loss?
Yeah.
Amongst other things, be exposed to breach of trust claim by the trustee because any all assets are assets of company for the purposes of the company, Article 74 of the Articles of Association. And we say that any improper use of assets by way of costs is leads open to the claim by the trustee for breach of trust.
So it's improper. That assumes that therefore the fees paid to directors can be shown, and the operating costs generally can be shown to be improper.
That is the allegation, yes.
Okay.
So the company incurs costs to external advisors and indeed internal costs of staff and directors, and charges the fund for that, and the fund pays. What's the loss to the company?
The loss is the increased call it has on the indemnity by the fund.
It's not a lot. The company suffered no loss. The company said, these are our charges, and the fund pays.
Yes.
Where's the loss to the company?
Again, at the risk of repetition, we say it's a function of the nature of the company purposes and the Articles of Association limiting the basis upon which the assets of the company can be applied. We say that
Limiting the basis on which
which assets of the
company can be applied.
yes.
These aren't the assets of
They're not the assets of the company. I don't understand.
These are fees and expenses which the company is charge the fund
Yes.
for.
We're back to the debate we had yesterday, but by way of reminder, so I don't misquote, tab 25, supplemental bundle, if I just read it, time. The income and property of the company, whensoever derived, shall be applied solely towards the promotion of the objects of the company set forth in the Articles of Association.
Yes, those are the assets of the company, not of the trust. And the assets of the company have been applied to discharge its liabilities. Because what's happened is, pursuant to the fees charging arrangement, the company has said to the trust, these are our fees, these are the expenses we have incurred in the management of your trust fund. Please pay the bills. The money from the fund has been used solely to discharge the liabilities that the company has incurred in managing the fund. Why do you say that the property of the company has been applied other than for the purposes of the company? It's been used to discharge its liabilities.
But liabilities have to be properly incurred, otherwise there would be no limit to what could be applied.
Where's the pleading that these liabilities, the money that the directors have been engaging unnecessary, inappropriate advisors, personnel, where's any specificity in this? I mean, what are you saying? Are you saying the directors have been expending money and charging the fund for inappropriate things, or what?
We're saying that the increase in operating costs evidences a prima facie case that the costs charged incurred, are excessive and improper.
Why?
Why?
You
You
can't
look
just
at them in terms of the percentage
Yes.
of net assets, which is the bottom line
Yes.
on this page. And it's a fairly consistent picture. And
Well-
I mean, I don't know, but I imagine that some of the fees are charged on a percentage basis.
council's fees have doubtless gone up between 2007 and 2020. Is that prima facie evidence that they're
They certainly
inappropriate?
have.
Is that prima facie evidence of inappropriate charging?
No, but it's not a fair analogy, because one of the aspects of the claim is that one of the benefits of a large scheme is that there should be economy of scale and expense, and one hasn't seen that at all. The company are trying to justify the figures by benchmarking them against other schemes. We don't know the details of those benchmarking. The schemes will all be smaller, but notwithstanding that, despite the increase in assets over time, generally, understanding what my Lord the Chancellor says, the overall trend is that the percentage has gone up.
But the loss here, if there's any loss at all, is a loss to the fund, isn't it? I mean, it's the fund that has lost money here, if you were right, not the company. I mean, the company operates on the basis that it incurs costs and the fund pays it to discharge the liabilities. So the company's neutral. The company's flat on any footing on this basis. We saw that in the accounts. This is absolutely a claim by beneficiaries, isn't it?
The problem with that is that the claim for breach of fiduciary duty, statutory duty against directors, is a claim held beneficially by the company. It's not held for the benefit of members of the trust. If it were...
Sorry, say that again.
Sorry. A claim under section 171, 172 of the Companies Act, claim by the company against the directors, is a claim which the company has beneficially. It doesn't have it on trust or holding for the benefit of the beneficiaries. Well, with respect, it doesn't. That would be contrary to HR and JAPT and everything else. I know your Lordship takes back to Article 71 of Underhill, passage in Lewis and we handed up this morning, gives the contrary view, and saying it's not wholly unarguable, having regard to HR and JAPT, of a one trust company. But we say This is the point we looked back to work out in the beginning whether there was a possibility of a dogleg claim. Concluded there wasn't, because the duties are owed only to the company, beneficially, available for creditors in insolvency. Contrast some of the other cases we were looking at yesterday, the Robertson-Gill lines, claims which are really held on behalf of the beneficiaries of the trust.
So I've sort of moved into, okay, let me just try and make sure I've understood what you just submitted to me, or to us. Let's say in any particular year, the company engages costs and expenses of £10 million. And it presents an invoice to the fund, i.e. it charges the fund £10 million to meet it and pays it out to the third parties, the employees, the investment advisors, and etc. If you're saying, as I understand it, the basis of the allegation is that's too much because, picking up your, I think I'm now going from your particulars of claim in this respect, but I suspect your skeleton says something similar. If that's too much, either fund has been overcharged by 10 million, the consequences are that there would be no need for change to the benefit structure of the scheme if there had been those charges had been less.
Yeah.
And if you were right, your clients could pursue the directors for that claim for breach of duty. So that, for example, instead of the 10 million, let's say it should have been 5. So the directors pay up damages of 5 million. And where does it go? On your footing, it certainly doesn't go to the pensioners, doesn't go to the fund.
It would go to charity.
It just stays in the company and goes to charity. Where does it go? Where does
Well,
that 5 million go?
It reduces the claim on the indemnity provision as between the company and the trustee.
Why?
Because that's the nature of the relationship between the company as corporate body and the company as trustee.
Why should it? Next year, the fund incurs charges of another 10. Sorry, the company incurs external advisors of 10 and quite properly bills the fund 10. Why is it obliged to reduce the charges to the fund by the 5 that it recovered? Are you saying that it holds the 5 on some sort of trust for the fund?
As the consequence of the proceeds of a claim. Or
Yeah. Because you were submitting, you did submit a moment ago that
Yes.
the company held it beneficially.
yes,
Well, if the company holds it beneficially, why is it obliged to give a discount the following year to the fund?
because of the articles of association.
Why? What
Because
do you
that's what
say about this?
They provide for the application of the company's assets and the purposes and how the property is to be applied.
Yeah, okay,
Yes.
so the company may say, well, we've got this 5 million, we will use it for our purposes, but there's no obligation to hold it for the benefit of the fund. If it owns it beneficially, I was surprised yesterday when you gave me the answer you gave me, and I'm just as surprised this morning.
We say that that is the orthodox. I'll make this point, then I will move on to claim 4 in the interest of time. We say that that is the orthodox position under law, that a claim by a company against a director is not held beneficially or for the benefit of any beneficiaries. That would lead to some quite surprising consequences. Imagine the insolvency of the company would be insulated from that to be part of the assets of the trust.
Yes, but if
That would,
well,
Yeah.
except, I mean, again, this,
Yeah.
if the whole
Yeah.
ethos of the claim, the underlying claim was that the fund has suffered and as a consequence of has not been able to do all the things you've pleaded out. Actually, I personally don't see any reason why it wouldn't be implicit that the recovery should be held for the fund, because it's the fund which the company exists to manage. And I find it pretty extraordinary that actually you are submitting that, given that that's the basis for the claim, the recoveries, if there were such recoveries, would not be held on trust for the fund.
That's supported by the passage in Lewin we handed up this morning.
Yeah, which is why I was testing
Yes.
it, because you've submitted to me twice now that the contrary is the case.
No, sorry, I'm speaking the other way. The passage in Lewin considers the pros and cons of it, but says that the better view, the preferred view, is that the claim is held beneficially by the company and not on trust or for the benefit of the beneficiary.
Well, in which case maybe we'll have to express that, but
And
express a view on it. But the oddity of it is
Yes.
that the loss that you the consequences of what you say is a loss to the company are actually the consequences to the fund and its beneficiaries, and the company suffers no loss.
But this is I'll make one further point on this and then I will move on, but this is a consequence of what's become the biggest issue in the structure of this claim. Otherwise, if your lordship's inclination is correct and that ultimately this is held for the benefit of the beneficiaries, and the beneficiaries can bring a Robertson-Gill style derivative claim, we say that would cut across HR and JAT, which makes it quite clear that directors owe their duties to the company and even to...
Do you know, I think if I was judging a competition between the Supreme Court in Robertson-Gill on the basis of the authorities they cited, and with all due respect to the judge who decided HR and JAP, who I don't have in front of
Justice
me,
Lindsay.
Yes.
I think I might have to go with the Supreme Court.
No, well, as a matter of precedent alone, but we say that even that doesn't appear from there. Robertson-Gill is talking about a different kind of case and acknowledges the parallel.
Why is it talking about a different type of case?
Because it's talking about a claim, one of the essence of the ability of a beneficiary to bring a Robertson-Gill style claim
So
is that the claim in question is held for the benefit of the beneficiaries. If it's not, you can't avail yourself of that procedure. So that's the crux upon which that whole derivative procedure works. And our starting point is to say, and we say this is orthodox, is that in the case of a claim by a company against a director, that is different because the directors owe their duties exclusively to the company who has the benefit of that claim beneficially, I'm using that word tautologically, I apologise, but not on behalf of someone else, namely the beneficiaries. Now, if we're wrong on that, then a whole new universe opens up. But we say that having regard to HR and JAP, having regard to Lewin, regarding to Underhill, Gregson as well, that it really is not sustainable to say that the directors owe duties to the beneficiaries.
But that's not the basis of the Robertson-Gill argument. The basis of the Robertson-Gill argument is that the beneficiaries can bring, exceptionally, can bring a claim in the name of the trust, in the name of the trust company here, the trustee.
Yes.
In the name of the trustee. So in other words, their claim, it's not the beneficiary's claim,
No.
it's a claim by the trustee against its directors.
No, I
I'm speaking
recognise
for myself, I don't think anything in Mr. Justice Lindsay's judgment goes anywhere near saying that somehow is not permissible.
and that's why there are the
And
parallels.
if it did, it would be wrong.
And that's why there are the parallels, my lord, between the two derivative claim mechanisms, as your lordship said at the very beginning of proceedings yesterday. So that's what that all goes back to.
Anyway, I think we really should move on.
We really should move on. Claim 4, the environmental claim.
But before you do that, can I just say that perhaps your answer in relation to the 5 million that's recovered from the directors in Justice Snowden's example, and I think that's what you were grasping at in relation to the Articles 71 and 74, and it's possible that 74 says the income and property of the company should be applied solely for the promotion of the objects, and 71 has the objects, which is of course discharging all the duties on behalf of the of the scheme. And so it might, I suppose, say, putting those together, that you get 5 in as a result of a claim against the directors. You, the company, then have to use that 5 for the purposes of the scheme, which means that rather than giving it back, you may pay the next bill yourself. Yes. Query.
Yeah, I mean, that's a possibility.
Anyway, let's move on.
Grasping is the operative word, my lord, but that is indeed what I was seeking to say.
Right, okay.
Claim for the environmental claim. This engages all 4 grounds of appeal, including the question of discretion. The essence of the claimant's claim is this, that the continued investment in fossil fuels gives rise to significant risk of financial detriment, that being the test recognised in the Supreme Court in the Palestine case, and being, I submit, a fortiori, the test for assessing pension scheme investments. We say that the continued indefinite investment without a credible plan to address or mitigate these risks is contrary to 2 duties under the Act. Section 171, the duty only to exercise powers for the purpose which they're conferred, and Section 172, the duty to act in the way which the directors consider in good faith would be most likely to promote the interest of the benefit of the members as a whole. In the claimant's positions, there is a clear and at least prima facie case that the failure to devise any proper plan to manage climate risk, particularly in the form of divestment, is a breach of those provisions, and that the directors have furthered their own ends by looking at other considerations rather than the company's omissions and the scheme members' preferences. Now, the judgment makes a number of criticisms of the claim, including the lack of documentation in support, the lack of particularities as to the extent of loss suffered, etc., etc. I'll try and deal with those when we come to them in turn. The factual scenario, dealing with this as briefly as we can, is as follows. We say, given the nature of the scheme, for the reasons set out yesterday, the company's investments are, as it recognises, long-term. There are numerous mentions in the primary documentation to the long-term nature. We've seen some of them. Perhaps I can just give a few of them for the court's note rather than taking the time to go to them. Now, they include tab 32, page 196, reference to unsuitable ... over the long term. A reference on page 486, the group has a long-term focus and purpose and is a responsible long-term investor. One can test that against the reality of the scheme being open to new members, open to future accrual. Someone who joins the scheme today, as things stand, will be in service for a very long time.
Yeah.
It's common ground and accepted by the judge that the company invests in fossil fuels. There's reference in some of the documentation to companies such as Rio Tinto, Anglo-American, Glencore, BP, Royal Dutch Shell. Also, some of those are mentioned in the particulars of claim. The extent of the fossil fuel investment is not clear. But what is clear is that the company has never said, we have a negligible investment in fossil fuels. What is apparent is that the company doesn't seem to be aware of the extent of the investment. And one can see that from the deck of slides which appears in the bundle, where effectively they say we don't have the metrics yet. And in order to know where to go, one knows where to start from. Those are important documents, and I'll ask the court to turn to them. It's in Supplementary Bundle 2. It's in the second volume, tab 67. We haven't looked at them yet, either yesterday or today. They were part of the unilateral suggested reading from the claimants.
67.
67 slides produced on behalf of the company February last year.
Yeah.
One needs to look at them in landscape. Starting with bundle page 722, The right-hand box, to assess the progress, you have to know your start point. The scheme has been undertaking a review of it should be climate data providers, one assumes, to assess which we feel provides the best data and service. We can't just have public market data. A third of the assets are in private markets. A considerable proportion of the credit benchmark is unlisted. So effectively, they're not sure of what investments are, particularly in relation to fossil fuels. 2 pages on, page 724.
Sorry. What are you saying this shows?
Well, that the company is unaware of the extent to which its assets include fossil fuels. Is it 50 million? Is it 100 million? Is it 5 billion? Is it 50 billion?
So the company buys shares.
Yes.
It doesn't actually invest in fossil fuels. What it actually does is buy shares or other instruments in companies whose business may or may not include, in part, some connection with fossil
Yes.
fuels.
As well as mixed funds or whatever.
Right, so what, are you saying the company needs to have, it was what, wrong for the company not to have, at this point in time, an absolute quantification for how much of its investment
That may go
in
to-
shares is reflected in the underlying company's investment?
That may go too far, but it has to have some appreciation of the extent of its investments, direct or indirect,
Right.
in these matters.
Okay, yeah. And what are you saying that's, which bit of 722 do you say evidences that the company didn't have it?
Well, it's saying to assess progress, you have to know your start point. It's been undertaking a review of climate data providers to assess which we feel provides the best data and service.
So
Next bullet point.
am I looking at 722?
722, my lord, yes.
Yes. The scheme
The
has
box on the right.
Okay.
So this is all preliminary to that process, in essence. It's saying we are looking for climate data providers, in other words, to carry out this assessment of things of the extent of the investments.
Right. So you're saying what? The directors were in breach of duty as at September 22 for failing to have got on with this earlier.
Sorry, for
Is this, what are you saying? Are you saying the directors are in breach of duty at this stage for not having done this earlier?
yes. They need to have some appreciation of the extent of their investment in order to devise a plan for dealing with what I say is the risk of such investments.
So it's the fact that on 722 they say they will establish a set of
Yes.
principles rather than having done so.
Yes. While within this document, it's helpful if we turn to page 717, which sets out the position. 717, second bullet point, we cannot divest our way to net zero. The economy and the assets in which we invest have to transition over the next 30 years. That was a reference to the net zero date of 2050. This means that USS has to play its role in engaging with the assets and the markets in which it invests.
Right. What's wrong with that?
Well, begs the question, first of all, what are the extent of the investments? But secondly,
Who is David Russell?
he's an employee on behalf of USSL.
But these are his own views, they're not the...
But I say they carry the imprimatur of the company, and I'm about to take you to one of the witness statements, which neatly encapsulates the thinking which this paragraph reflects.
Okay, because at the moment I'm looking at the disclaimer which says the views in the slides are his own views and not those of USS.
But if we turn up again, the supplemental bundle 1, again it's the witness statement to Mr. Atkinson, tab 4. Paragraph 59. says, second line, the most recent training takes the view that divestment from certain investments is not an appropriate way to achieve net zero. Divestment has limited impact on climate change because if USS sells an asset, another investor will necessarily buy it, such transaction therefore having little, if any, impact on the underlying company or its carbon emissions. Rather, USS will have to play its role in engaging with the assets in the markets in which it invests.
Yeah.
Now, I say, as we shall see in due course, that that position there is entirely reflective of the director's approach to this.
Yeah, but you say that's, what, wrong? A breach of duty? I mean, to think that you could, it's better, is it wrong to form the view that if you're a very substantial market investor, you can have more influence on the underlying companies in whom you are investing by retaining your investment rather than selling it to somebody else who may not share your views?
No, but I would put the point this way. What is wrong is to focus not on the reduction of fossil fuel investments, but to look at the global reduction of things. What the director's primary concern was through the prism of the company, looking at the company's fossil fuel investments, direct or indirect. So we say that's what it failed, what they failed to do.
So that it was wrong not to focus on the reduction of the scheme's direct investments in fossil fuels.
Yes.
And instead to focus on a broader approach.
A broader approach, we say, is not irrelevant, but it's not the primary concern. The primary concern has to be from the company perspective, the company to whom the directors owe their duties.
Right, so, and what, the company's interests are served by maximising the return on investment, however that's achieved?
Well, the obligation, the interest of the company is to obviously achieve a return. One can have regard to non-financial factors. In fact, the way we criticise the investment in fossil fuels here is precisely on a financial basis, given the long-term nature of the scheme and the company. Fossil fuels have a limited shelf life. However profitable they might be temporarily, however good investment they might be on a short-term basis, given the long-term nature of the scheme, it is unsustainable to continue to invest in them.
But just to understand, is it your case that they should divest themselves of all fossil fuel investments this year, next year, 3 years' time, 5 years' time, 10 years' time? What?
I'm not being surprised. They need to have a plan to.
But they're formulating a plan.
Well,
Because the point,
Yeah.
one of the points that's made, I think, I'm right in saying, is well, at present, these investments are actually extremely profitable.
yes, and that's why partly why we phrase the allegation in the way we do. But nonetheless, they won't remain.
I mean, I follow the point that in 20 years' time, it may be that investment in Shell or BP or Rio Tinto or whatever won't be worth the paper it's written on because we won't be using fossil fuels. But at present, and for the foreseeable future,
Well,
it seems to be a profitable
yes,
investment.
but my lord, with respect, it's not simply through the prism of 2050. It's also the prism of 2030, by which 45% reductions are supposed to happen, part of the Paris Agreement. So I say that is within the foreseeable future. So it's not just that.
So the nature of your complaint is they may be suggesting by the slides that they're going to get on and formulate a plan, but they haven't, and so far as you know, yet, and they're just not getting on with it quickly enough.
There's several strands to that. There's no evidence of a plan, which doubtless they could have put in evidence. Notwithstanding the Paris Agreement in 2015, which rather focused the minds of everyone on every level to these concerns, they haven't identified the extent of their investments. They haven't come up with a plan. Even if 2015 to earlier date than the IPCC report of 2018. Against that benchmark, they haven't done it.
But you see, your pleading case is that they should have done it now, and their breach of duty is to fail to have divested prior to now and immediately. I mean, your answer to my lord is very different to your pleading case.
If I check that for a moment.
Your pleading case is they've breached duties because they have not divested now, and they must divest immediately.
That's, I'm not seeking to
That's your
answer
big
that.
case.
Yes, no.
105. I mean, tell me how else I should read 105.
Immediate plan for divestment, disinvestment mode.
And the only rational action that the directors could take is to devise and implement such a plan as soon as possible. So so the USS should divest itself of all carbon related investments next week.
No, it's an immediate plan for disinvestment. It's not a plan.
And implement it as soon as possible.
It's not a plan for immediate disinvestment.
Well, it is, isn't it?
Yes.
I mean, to implement a
Implement it
plan
as soon as
immediately
Met by
and implement it as soon as possible.
That is not what it's meant to
You're going
be.
to implement the plan next week and put it into effect next month or
That
maybe
is,
next year, but certainly not something
that's
down
then
the line.
deficient drafting. That's not the intention, because clearly there would be financial consequences of immediate divestment.
Yeah.
We're alive to those concerns.
But whilst we're in the pleading, could I also ask you about paragraph 112, which is that it's suggested that the breach is takes one back to 101 to 105, but then they further their own interests, it says, and they put their own beliefs ahead of the interests and beneficiaries of the company. Where do we get the beliefs?
I'm going to come to that.
Good.
Right, okay.
What I was next going to do, it's in supplemental bundle, maybe volume 1. It's the results of an ethical
Which tab?
survey. Tab 34, my lord.
Yeah, it's volume 1.
If we just look at the headline figures, then we'll give some context as to who was surveyed and who responded. Second entry, fossil fuels, about it's over 0.6.
So page, what is
My lord,
this?
277, it's in landscape, it's behind tab 34.
Sorry,
It's a
what is it?
graph. In your opinion, should all companies involved in the,
But what is this?
sorry?
The Maastricht University team.
This is a survey, I'm about to explain, it's a survey of USS active members as to their investment views. On the heading of investments we see down the page, the second one,
Only actives.
only active, yes, fossil fuel, is the second one, and about in excess of 60% saying that they should be excluded, and no about just under 30%, and don't know another figure, maybe 10%. I say a clear majority, broadly by a factor of 2 to 1, in favour of disinvestment. We move on a couple of tabs to tab 36. This explains who was surveyed, and one gets that from page 335.
So what? Wait a minute, so you're saying, so why are we being shown surveys of active members of the fund? I don't understand.
Well, because that's, my lord, a relevant consideration. We'll see why in the context of pension trusts and the regard one has to the interests of beneficiaries. And part of the question asked by my lady a few moments ago, to what extent did the directors further their own ends over the interests of the members?
But they, in relation to investments, they have obvious duties in relation to investments, and it's for the directors, it's for the trustee company to decide. And overall, they may also decide all sorts of things about investment. It's not for the, just because this is a pension scheme, it's not for the beneficiaries to drive the investment policy. And look at Cowan and Scargill.
No, but turning on its head, it's not for the trustee, for the directors to favour their views over those of the members. And that's quite clear from Parish and Church Commissioners, Cowan and Scargill itself, Palestine,
When you say their views, they have to form a view as to what is in the best interests of the company.
Well, I say they haven't done that, but what they have done, they do have a view that disinvestment is not the way to go about it.
Sorry, you're saying that they have actively formed a, well, okay, go on, you better show us what you rely upon.
So this is the survey. One sees the extent of those who were contacted and the responses given. There are just under 4,000 responses, 2,000 linked to admin data for further analysis. I think it's not an insignificant survey.
Well, it's a survey of what, over 400,000 members of the scheme in all. Is that right?
Yes.
So it's a survey of 1% of the membership. For better or worse, it is a survey of 1% of the membership.
Yes. And there are no other surveys in here showing any countervailing predisposition, whether of retired members or whatever. But we also do know that there are other bodies campaigning for the divestment of fossil fuels within the scheme. One sees that from the judgment of paragraph 124. That's the reference to USS divest. It's instructive. 144, oh yes.
Yeah. So I'm sorry, I'm looking at the wrong place. What paragraph?
No, it's 124. I'm sorry,
124.
I gave you the wrong reference. So this is an extract from the evidence given on behalf of the claimants, particularly the quotation at the bottom of page 221 of the bundle, paragraph 46 from Dr. Davies, as he then was, his third witness statement in reply.
Sorry, I am lost.
Yes.
Give me the bundle in the page.
Certainly. SB,
No.
No.
Core bundle.
sorry,
page
core
221,
bundle 16, judgment, my apologies, page 221,
Paragraph 124.
paragraph 124. I'm
Which
grateful.
quotes the paragraph of Mr Atkinson's witness statement.
No,
But in fact, no, what that is, that's
so
Dr.
it's Dr.
Davis
Davis, actually.
responding
Okay,
to Mr.
thank you.
Atkinson. And at the very bottom, I'm sorry, this is slightly cross-referential. Very bottom, we see there, in October 2018, USS Divest, separate group of which the claimants are not members, emailed the USS directors about the risks associated with climate change and received only one reply from Professor Hutton. In March 2019, USS Divest sent a letter from 20 academics requesting details of the sources USS had used to assess climate change risk, how they had taken climate into account in their planning, and the financial justification for continuing to invest in fossil fuel companies. USS sent no reply. So, what I'm seeking to establish on the things is, first of all, the two claimants are not lone wolves. We've got in the survey, we've got USS Divest. Furthermore, there is reference in the judgment in the bundles to the fact that this claim is being crowd-funded, a point which my lord the Chancellor touched on in his address to the commercial bar last year. We had below details of because the other side put it in, details of the contributions made. The figure has gone up considerably since. I'm happy to give it to the court. It's not evidence before the court.
No.
Having said I'm happy to give it, I have missed.
Where does the judge deal with this claim?
I'm sorry, deal with this bit of it. In paragraph 124 we were looking at in the judgment. That's the claimant's evidence.
He deals with it later at paragraph 186.
Yes. Yeah, so he deals the structure of his judgment, deal with the evidence, and then turning to his analysis, paragraphs 186 and following. For the benefit of the court is interested, the total amount pledged by crowdfunding is 466,000 odd from 11,780 pledges. the latest figure this morning. It may have gone up since, marginally, one assumes. As I prefaced some 10 minutes ago, the appropriate legal test is whether there is a significant risk of financial detriment. That's the test confirmed by the Supreme Court in Palestine Solidarity. It's in my skeleton argument. Very conscious of the time. We won't go there. I say that is the ultimate position. And I say that continued indefinite investment in fossil fuels is a significant risk of financial detriment. And the reason it is a risk is a combination of a number of factors: the unique, unprecedented nature of climate change itself, the international treaties, such as the Paris Agreement, and the goals set out there. Not all of that is necessarily enforceable, but there are goals and enforceable parts of the Paris Agreement. Clearly, the temperature goal of 2%, and then brought into focus with ideally below 1.5%. These are all part of the backgrounds as to why there is a risk of significant financial detriment of indefinite investment in fossil fuels. Some of these points have been reflected in legislation, and there are a host of court decisions internationally and nationally, and my Lord knows them well because you looked at them for your address last year. But again, in the interest of time, Urgenda, case of the Supreme Court of Netherlands, that ordered the state to limit emissions. Friends of the Earth and Royal Dutch Shell, which was a Dutch decision, part of the backdrop to the decision of Justice Trower, that ordered Shell to reduce.
Isn't it? Not
Sorry?
It's not Friends of the Earth, it's Client Earth, which is a different organisation, I think.
Yes, no, you're quite right. It's different. It's Client Earth. Apologies. They're Friends of Earth.
It was an
another one.
associated, from recollection, it was an associated organisation in the Netherlands.
Netherlands, yes.
And then one of the points that was made before Mr. Justice Trower was that they had failed to comply with
Yes.
the order of the Dutch court.
Yes, and there was an interesting debate about that. But
Yeah.
the important point is that the Dutch court ordered Shell to reduce emissions. And one of the issues in relation to the English claim is the fact that Shell had freedom to reduce emissions as they saw fit. So the nature of the attack there was on the very detailed plan Shell had devised.
Yeah.
Not to do that. I say by comparison here, there is no plan.
Yeah.
Klimaschutz, the German Federal Constitutional Court, declared national legislation incompatible with provisions of that agreement and fundamental rights, including Article 2 and Article 8. Now, I'm not relying upon necessarily some of those as precedent in terms of these, but as part of the backdrop and the risk of the significant risk.
There are other claims that are, which
Financial detriment.
have not reached
No.
the conclusion. There's a claim in Germany by,
Yes.
by the Peruvian farmer.
Yes, exactly.
And there's the claim by the grandmothers in Switzerland.
Yes, so there's
It's
a
gone
range
to
of
the
those,
European
some of
Court
which
Human Rights.
we've spoken about, but they're all part of a phenomenon.
Yeah.
Doubtless why your lordship gave the talk you did.
No, that's right, and
Yes.
I follow all of that, Mr. Grant. The point that troubled me at the moment, most of all, was how this is said to be a breach by the directors of the duties under section 171, 172, particularly the 173. If their belief is that it's in the best interest of the company to continue to invest and to adopt the approach that's set out in that slideshow you say.
Yes.
What's the basis for saying that that's they're not acting in good faith?
Can I seek to answer that in 2 minutes after dealing with one final
Yeah,
bit,
sure.
which is that everything I've just said, all those aspects, the litigation, everything else, let alone greater activity going on, I say those all effectively neutralise the judge's criticism of the lack of evidence put before him. The real question there was whether there was a risk by the holding of judgments. And I say he went about it the wrong way.
Yeah.
That was the question.
Yeah.
One can even make an analogy, again it's not my analogy, that investments in fossil fuels are now rather like a 23-year-old lease. Even imagine a lease in Eaton Square, at a time when property is booming. Nonetheless, it's a lease for 23 years, and its value must reflect that short-term nature. So we say the legal argument.
Unless you're hoping that the Grosvenor estate would allow you to
There will always be counterfactuals, my lord,
franchise
yes.
the
The argument, the section 171 argument, ultimately is that the failure to have a plan and to divest the investment on the apparent belief that divestment doesn't work because it doesn't reduce overall carbon emissions is not an exercise of the investment powers for the purposes for which they were conferred. Because it's looking at the wrong purpose. It's not saying what the purpose of the investment powers is to invest in this company. It's looking at something bigger. And I'm not saying that that's an irrelevant consideration, but it's not the primary consideration which the directors should have been considering.
Yeah, but hang on, that's just answering
Yeah.
the allegation that they should have. The whole allegation is based upon a belief that fossil fuels are bad for the world, which is a perfectly tenable view, and that it should be addressed by divestment. And the point's being made, well, if you want to change the world's general dependence on fossil fuels, the way to go about it is not by divesting, but is by using your influence as a massive investor in the companies that are whose businesses include fossil
And the
fuels.
response-
Are you saying that's irrational or an improper view of the directors to hold?
I say it's
Assuming
irrational.
that they hold it.
It's irrational to think that that will work on its own without anything else, because one isn't realistically going to engage with someone like Shell to stop being a fossil fuel company, at least in the short term,
So you do say it's irrational?
Yeah. in relation to this.
And so
Yeah.
whose evidence or what evidence do we have to show that it's an irrational view? Or as opposed to just one that your clients disagree with?
Well, that's a fair, an unfair collapse with respect to my lord, but what we say is that on the basis of everything I've said, on the basis that the director's apparent position is, well, actually, we're not going to divest, that's not the right way to go with it, because that has no impact on overall global emissions. What they should be focusing on, risk of repetition, is the emissions of this company. There is a place clearly for engagement, but it is not the be-all and end-all. That's the point that's being made. And we say that allied to that the section 172 duty promoting the success of the company should have been focusing on the risk of the company of having these fossil fuel investments, not looking at any bigger picture. And that's something which we say the directors, and the evidence seen so far, have not considered. There's been no engagement with the risks of holding fossil fuels. The slide deck I showed barely mentions the question of divestment. It's simply not been engaged with. So we're a world away from the Client Earth and Shell case, where Shell, clearly a fossil fuel producing company, had very clearly Client Earth didn't like what they'd done, but very clearly had a plan for reducing their emissions.
Have you actually shown us anything which, by the directors, which actually expresses the views of the directors on this subject?
Not expressing, I haven't shown you board minutes or anything like that, but I say it's implicit from what's being done. We're proving a negative. There has been no plan, anything, and the best evidence in terms of their approach, said is in that bit in the slide deck, saying you cannot divest to net zero, as helpfully characterised by Mr. Atkinson in his witness statement, to give the rationale for it. The rationale being, i.e., presumably the one to which the directors subscribe, is that this won't work because if USS sells investments to someone else, hedge fund or whoever, will come along and buy it. There may be something in that in terms of an economic analysis, but that's the wrong question to ask from the company's perspective. So we say that for all these reasons, the judge was wrong to say that there was no reason for a trial. USSL's evidence didn't engage with, let alone refute the claim. Reliance on Regulation 4 with investment regulations, diversification, doesn't answer the question whether there's a significant risk of financial detriment. And the claimants say that in terms of the directors' failure to adopt a plan furthering their own ends, That's in the evidence in the slide deck and Mr. Atkinson's witness statement. Effectively, they put their own beliefs with regards to how to engage with this matter above the interests of the company and the scheme. And they did that crucially, preferring those beliefs over the members' apparent support for divestment. And I would invite the court to have a look at paragraph 44 of Palestine Solidarity.
Paragraph 44.
For Palestine, it's composite bundle towards the end, tab 71, page 1107. The bit ends with regardless of the views held by the scheme
Sorry,
members.
tab what?
Composite bundle, tab 71.
Yeah.
Page 1107.
Yeah.
Paragraph
44, my lady, is highlighted.
Yep.
It's agreeing with the submissions of leading counsel. Of course, that's a rather different case contextually. But again, the point I don't is that in that case, promoting the government's political approach regardless of the views held by the scheme members. We say here, this is a question or an evidence of the directors promoting their belief as to how to go about dealing with this, over and above or regardless of the interests of the members.
But going back to, I just draw attention to this, back to the slides, which are at 67. One looks on page 711. The gentleman who wrote those slides does point out fiduciary duty, question mark, what the fiduciary duty is, and then insofar as climate change carries material financial risks, trustees will need to consider it as a core part of fiduciary duty. Trustees should therefore consider climate-related risks and opportunities in the context of existing legal requirements relating to fiduciary duties. These include the exercise of investment powers, etc. So it's not as if this document either suggests that it shouldn't be being considered in relation to the duties to the scheme and the best interests of the beneficiaries, which actually mentioned that.
I say that those are all fine words, but they don't accord with the reality of the situation, which has been a lack of engagement with the views of the members and the absence of any plan. We say that that makes that a prima facie case, and by extension a case on furthering their ends for the reasons I've just explained. In terms of standing, we say there is a loss to the company, is the exposure of risk, and there is a reflective loss for the members. And in terms of discretion, we say that all the reasons why the judge was right to find that he would have exercised his discretion in relation to claim 1 apply here. All the same difficulties there would have been with a direct breach of trust claim also apply to this.
So, why the judge just said, if your clients as beneficiaries of the trust think that the trust has not adopted an appropriate policy in this regard, they can sue the trust.
But that would be the same in relation to claim 1.
Correct.
But he didn't say that. I'm saying that he was right not to have done so, and that the arguments must be consistent for the claims. It's slightly odd to say it was a matter of the exercise of discretion, find that it's not appropriate to bring claim 4 for those reasons, but to find that those reasons aren't sufficient obstacle in the context of claim 1.
Right.
That's the point, my lord. It stands or falls together. Doubtless to the delight of everyone, I have come to the end. I'm grateful to everyone involved and my learned friend Mr. Short
Well, we've
for the
been
indulgence.
probing your argument in some detail, Mr. Grant. I hope you feel you've had the opportunity to develop your thoughts.
By hook or by crook, I have got across, I think, what I wanted to.
Thank you very much, Mr. Short.
My lords, my lady, what I propose to do is to deal first with the Roberts and Gill point and explain why the case was dealt with in the way that it was by Mr. Justice Leech. And I hope to do that and finish that before lunchtime. And then I'll deal with the 4 grounds in turn, dealing with the application of each ground to the individual claims as I go along. Perhaps before I do that, I'm going to just clarify the language I'm going to use. And this is particularly in relation to the Robertson-Gill point. That sort of claim, I think, has been referred to as a beneficiary derivative claim. That's quite straightforward. Another sort of derivative claim is the statutory claims under the Companies Act. That's self-evident. And the other type of claim, brought as an exception to the rule in Foss and Harbottle, considered in Waddington, Aberraya, Fort Gilkicker, has been called in some of the paperwork, in some of the cases, a multiple derivative claim, but that's not always appropriate. Certainly it wouldn't be appropriate here because you don't have tiers of responsibility. So I'm going to call that sort of claim a common law company derivative claim because it's subject to the common law rules as pointed out in the authorities. Now, if I could ask the court to turn to the core bundle and at tab 17, I'm going to deal with these in the order in which they appear in the bundle. Tab 17 is the application notice that was used in this case, and at the bottom, paragraph 3, what order are you asking the court to make and why? And it's under the common law principles analogous to section 261 Companies Act in order the claimant have permission to continue the multiple derivative claim on behalf of the first defendant. First defendant then asks for costs. The next tab, tab 18, 258, has the claim form itself. And under brief details of claim, it says this is a multiple derivative claim, i.e. it's a common law derivative claim. And then when we get to the particulars of claim, tab 19, paragraph 1, which is at page 265, says these are the particulars of a claim of a multiple derivative action brought under common law principles analogous to those set out in Chapter 1, Part 11 of the Companies Act. So the claim as made was very deliberately framed as a common law company derivative claim. And that's why this application was made, but the application was then dismissed on paper by Mr. Justice Leech. His reasons are short, but in my submission are helpful. They are at tab 10. So tab 10, page 151 is the order. The reasons appear on the second page, 152.
Yeah.
And you can see paragraph 1, so some of this was in my learned friend's note from yesterday. Paragraph 1 refers to what's happening, that a multiple derivative claim is being brought. Paragraph 2, Justice Leech said, I'm not satisfied present claim can properly be described as a double or multiple derivative claim, or that I should apply this procedure, not members of the first defendant, etc. Then refers to dogleg claim, C. Gregson and HAE trustees. And then at 3, I'm prepared to accept without deciding practice in CPR Part 19.9, as it was, applies to dogleg claims by beneficiaries against directors of corporate trustees. In my judgment, it remains necessary for the claimants to establish both grounds for a derivative action under company law and the grounds under trust law, and then refers to Lewin for that proposition. and the conditions set out in Lewin, the
Yeah.
sections that the court referred us to.
Yes.
before we started. But then, importantly, my submission, paragraph 4, it's clear that Mr. Justice Leech considered whether he thought there were special reasons, such as would permit a beneficiary derivative claim to proceed. He says, not satisfied, there are exceptional circumstances. He says exceptional circumstances rather than special reasons, but it's clearly the same point. In particular, not satisfied, Dr. Davis is correct when he says that the claim cannot be brought in any way other way than a derivative claim against directors. Moreover, it's unclear to me why a claim by individual scheme members would be financially unviable. Seems to me the kind of relief which the claimants seek would be more suited to an action for breach of trust directly against the first defendant rather than a dogleg claim against its directors. Now, with respect, we agree with what Mr. Justice Leech said there. Save that, we don't think we suggest there'd be no merit in those claims if brought.
Well, that's a different point because that's to do with the merits.
It is. But
Well, presumably merits has to, I mean, part of the exceptional circumstances test
yes,
in a Robertson Gill scenario must be, mustn't it, whether or not there's any
yes.
merit in the claim that sought to be made.
Mr. Justice Leech has already identified why it shouldn't have permission, why there aren't special reasons for these, on these grounds. Had he been asked to consider the merits, we suggest he would have reached the same conclusion on a very similar test in these respects as he did here. But the claimants chose not to pursue a flawed beneficiary derivative claim, but they very deliberately sought to disavow any such claim and instead to try and crowbar their dispute into a common law company derivative claim. And it is, in my submission, true that it doesn't fit very well within that framework. But that was a choice of the decision deliberately made by the appellants, and they must live with the consequences, one of which was Mr. Justice Leech's decision that this was not a common law derivative claim, which is one of the reasons.
So they never sought to pursue before the judge at an oral renewal a challenge to paragraph 4 as such.
No, they said paragraph 4 misses the point because it's not that sort of claim. It is a different claim subject to the common law rules. And the
Just before you go on,
Yes.
as a matter of fact, Mr. Justice Leech is wrong in paragraph 3, isn't he? He's wrong. I mean, paragraph 47(17) of Lewin is not this case. It's got nothing to do with this case. That's talking about where a trustee holds shares in another company and might be able to bring a derivative claim in the true corporate sense as a shareholder in that other company, but fails to do so, in which case, as Lewin says, a beneficiary would have to both bring a trustee derivative claim and would have to establish that the trustee was had the grounds to bring a corporate derivative claim, but in relation to a third-party company. That's what Lewin says at 417. It's got nothing to do with this case.
That's correct, although it's not material to his decision, because if it had been a beneficiary's derivative claim, it would have been subject to the special reasons test, which he does apply.
At some point, you'll need to explain to whether you agree with or otherwise that I think from what you said you do agree with this. That this claim should only be brought as a beneficiary derivative claim in the Robertson Gill sense.
Well,
if it's to be brought at all. I think that's
We-
I thought that's what, essentially I think that's what your crowbarring submission amounted to, isn't it?
yeah, my crowbarring submission is that it should not have been brought as a multiple, or as a common law corporate derivative claim. And the claimant's decision to pursue that was a very deliberate decision. So the only claim that was before the court was the common law derivative claim. They had not pursued, they deliberately didn't pursue the beneficiary's derivative claim. We say, had they pursued that, it would have failed for the reasons given by Mr. Justice Leech at paragraphs 4 and 5, and also on the merits, as it were, for the same reasons which he deals with in more detail in relation to the company derivative claim. But
If you're educate me, if you're pursuing a beneficiary derivative claim of the Robertson Guild type,
Yes.
i.e. you say the trustee is not doing something because it's under wrongdoer control or otherwise, which is what is being said here, in essence. The trustee has a claim against its directors, but it's not pursuing it because it's controlled by its directors.
well,
Why, as I understand it, the beneficiary, before they can bring a beneficiary derivative claim, has to show special circumstances to enable them to do so.
yes.
And one of the factual inquiries that the court might engage upon is whether their interests are allied with all other interests
Yes.
of beneficiaries, which is an inquiry which doesn't need to take place usually in relation to a company derivative claim, because if you have a share in a company, which is a requisite, other people have got the same interest because they are shareholders as well. So in other words, your interests are the same, but with a trust with beneficiaries, it's not the same because there are different categories of beneficiaries, of which pension funds demonstrate very clearly. You've got people in payment of benefit, future pensioners, and the like.
Yes, well, that explains why the claimants sought to go down this path. And they make very clear that one of the reasons they want to do this is to avoid the complications in a trust claim of different beneficiaries having different interests. We said that was one reason why they should
To
not.
avoid the complication that they have to show that they're representative
Yes,
of the beneficiaries as a whole, or sufficiently representative.
yes, and that they sought to avoid that step by, so I use the word crowbarring in a pejorative sense, but it's meant to be, crowbarred their dispute into a common law derivative action to avoid that. And it didn't work because this isn't a common law derivative claim. Now they deal with this in, I think, in the additional bundle you were handed up yesterday, where you have my learned friend's submissions for the oral hearing. And they're at tab 7, I think. And I'll just see, if I may, I'll just seek to finish this point
Yeah, okay.
before lunch, was paragraph 21.
Yeah, sorry.
Sorry, the submissions that they put in yesterday, paragraph 21. Sorry,
So it's in the Treasury tab, list of authorities. Tab 7, is that the one?
That's
Their submissions for the oral hearing.
yes, my lord, yeah, that's right.
Yeah.
And it's paragraphs 20 and 21, but in particular, paragraph 21 says, firstly, no allocation directors owe duties to pension scheme members. Secondly, or that the company holds on trust for the scheme members the company's rights against the directors. So that allegation wasn't made. That allegation would needed to have been made if this was to be pursued as a Robertson Gill type claim. I'll go very quickly to Lewin in that respect. Whether or not that was a correct decision is neither here nor there, because it was the decision that they made, and they pursued the claim, as I've said, very deliberately as a common law company derivative claim, and so they're held to that test. And just to make good the proposition that they would need to show the company holds on trust the rights against the directors to bring that sort of claim, I think your lordships have behind tab 6 of that supplementary bundle the extracts from Lewin and paragraph 47007. He makes the point that for such a claim, the need for the cause of action to be trust property, derivative action may not be brought by a beneficiary against professional advisors, trustees, until the cause of action is not taught it's not trust property. Now there may be complicated questions there as to the position, because this is a single trust company, and in fact the Japt case refused to strike out, rather than holding you can't bring these claims because they're dogleg claims, it refused to strike out a claim in not dissimilar circumstances. It didn't say you could do it, said it's not unarguable. But whether or not it was arguable, it wasn't argued, it was disavowed. The only claim that was before the court was a common law corporeal.
So cutting to the chase, as it were, and you say, well, if this court were to conclude that the claim that was pursued before the judge was without merit for all the reasons the judge gave, then the claimants can't save themselves by saying, well, we could have pursued a different claim as beneficiaries.
That's right. We say they couldn't do that anyway because they didn't take on the decision made by Mr. Justice Leech to say no special reasons or no exceptional circumstances. It would have failed anyway, but they didn't do that.
And you're saying that you're not going to pursue an interesting academic argument about all of this because you don't need to, because they are their colours are nailed to the mast, and you're going to deal with that as it stands.
Yes.
But, very good. Okay, but just, so I appreciate I'm trespassing on everybody's lunch, but at some point I'd like to come back and explain why, if there is a more obviously appropriate mechanism for the bringing of a claim, it is appropriate and not an abusive process to choose a less obviously appropriate mechanism, such as the common law derivative action, as you say. I mean, it's perhaps the alternative remedy type.
Yeah, it is.
Yes.
So, I mean, you're not, as I understand it, abandoning that argument.
No, I say that this dispute could have been brought forward in different ways by a direct claim. There's no need for any derivatives claims here. It would just be a direct claim.
Well, or a beneficiary derivative claim,
Yes.
if you are prepared to engage with the safeguards and requirements of it.
Yeah. So you either make a beneficiary's derivative claim demonstrating special circumstances against the directors, which is a claim on behalf of the trust against its directors, which is what they disavowed, or you make a direct claim against the trust company for breach of trust.
Yes. And in deciding whether there were special circumstances, the court would have been entitled to take into account whether a direct claim could have been made, as indeed Mr. Justice Leech did.
Yeah,
but I'll deal with that afterwards. But I do say there was no need for any derivative claim here. It simply complicates things. Rather than bringing a bad common law derivative claim, they could have brought a bad direct claim.
Very well. 2 o'clock, please.
All right.